Hello everyone, and welcome back to the anniversary. Today we have day 16 of the Raymond Davis trial. This took place on September 16th, 2019. Here we see continued testimony. Today it's the Detective Martinez who ultimately ended up arresting Raymond Davis. And throughout the testimony, we're going to hear a lot of requests for mistrial and even a comment that the prosecutor needs to stop dragging us up to the bench and objecting. It's taking too much time. I hope you enjoy.
I was confused again. I'll try it.
All right, we are back on the record, or we are on the record for the first time today in C342946, State of Nevada versus Raymond Davis. Mr. Davis is present with his standby counsel. Mr. Klaus, Chief Deputy District Attorney Ms. Kollins is present. When we were leaving on Friday, I asked you guys to come in at 12:45 because the jury's coming in at 1, so we could take up any issues outside of their presence that needed to be discussed. Do you guys remember that?
Yes, ma'am.
Okay.
So, the only issue the state has, Your Honor, is Adrian Walker is now in Hawaii, so I'm going to be requesting that she testify via video. I'm going to have all that information for the court. Mr. Conrad is typing it right now.
Okay. All right, understood. So I'll look at that when that comes. I'm just trying to remember. I should have written myself a note. There was a specific thing that we wanted to hammer out, though. If you guys remember when we left on Friday.
I do. I meant to write it down. Let me see if I did.
Do you remember what it was?
One was the statute of limitations for the grand jury indictment.
There was no written motion regarding the statute of limitations.
Yes, it was brought up orally, and you said you would look into that.
No, although there was one.
I do have a motion, and I filed one. Also, Your Honor, when I was remanded in jail, the first time I went down there, they took my property. They lost my briefcase. They lost my backpack. The jailers know it took like 2 hours to find it, and they kept me in booking while they looked for it. They had all my other property, they couldn't find it. So they found it, but obviously I never got that back. They put that in my property.
Wait, I'm sorry, we gotta break this down. So you're talking about when you were remanded in custody last week?
Yes, when you had me remanded in custody Thursday for the psychological evaluation.
Right, okay.
When I went there, I had my stuff. I mean, my stuff obviously was left up here.
Right.
So when they brought it down here and they were booking me, I asked the clerk, "Where's my briefcase and backpack?" And she said she has no idea. They haven't seen it.
Right.
And then one of the sheriffs came up to me. He said, "Yeah, I think we have it, but we got to find it." They then looked for my stuff for approximately 2 hours and found it. The next day I came to court. Obviously, they didn't give it to me. They put it in my property. So I never saw what was in there, what they brought or whatever. So now when I come back to court Friday, when I was frantically looking for some things, I didn't know if it was missing or whatever was in my car or nothing. So I basically looked over my stuff and it seemed like everything was there. Then when I went back into custody, which they had me in solitary confinement,
You mean on Friday after I had released you, but you had to go back to get booked out? Is
Yeah,
that what you're talking about, to get processed out?
I didn't get processed out. They took me back to solitary confinement
Okay.
to a room, and I had all my stuff that was from court, which was fine and dandy. Approximately, they woke me up at 6 a.m., told me they're going to cash me out, book me out. I was taken down to led by an officer with a couple of other inmates. They took all my property. I asked them, "Can I keep my legal papers? Because, I want them with me. I don't want them anywhere." The officer says it's not allowed. You can't have those. But we have a locker you can store your stuff in and it'll be secure.
Okay.
So he took me to this locker. I went to open the locker and there was no lockers. I told the officer that all the lockers was full of stuff. He says, okay, put your stuff on top of the locker. I said, on top of the locker? I said, these are my legal papers. I said, this is my Bible. I can't put it on top of it. He says, you put them on top or you're going to stay here and not be released. So obviously, I listened to the officer, put my paperwork on top, right in the open. They then take me into a holding room, and I stay there for about 2 hours. I come out, they give me all my paperwork, they process me out. Now, I don't get a chance to look at my paperwork. They don't let you look at paperwork or what you got or whatever. So they're basically processing me out. I get home and find out about 25% of my paperwork is gone. And not only is 25% of my paperwork is gone, my hotel receipts from California, my flight, my tournament records, I have none of it. My tournament records prove where I was. I called the jail. They said they have no idea. My stuff has been missing. The stuff that will prove that I'm innocent, from tournament records to all that, I don't have it. I no longer have it. So I'm asking this court to call this a mistrial because my stuff is missing. And it's to no fault of mine.
Well, why can't you just go get other copies?
Your Honor, it takes time. So you get one, I'll show you an example of something.
First of all, was this evidence that you were going to use in your case in chief with your witnesses?
Yes.
Okay, had you turned it over to?
I
the
wasn't going to
state?
turn everything over. I even got an envelope. See, I even had it. Because I didn't get a chance to do it because I was in jail for 2 days, but I even got an envelope here that says, I'll show you. I was turning over everything to the DA that I had.
I know, but the point is you have to turn in evidence, that type of evidence 5 days before trial.
Your Honor, I was in jail. It was hard to turn it in.
No. You were not in jail 5 days before your trial. You were out of custody on house arrest.
Your Honor, these are things like, I'll show you what I said. I had all these too. See, this is part of some of the stuff I got. Letters, and I had flight tickets, and I had tournament receipts. I'll show you what one of the tournament receipts look like. Those show where I'm at.
Okay, but I guess what I'm confused about, sir, is I'm trying to understand the relevance of these things because no specific date has been given, right? So it's not like, let's say she said, okay, on December 18th of 2016, this happened. And then you had a tournament stamp that said on December 18th of 2000, whatever, that would be relevant, right?
Right.
But no one has said that.
Your Honor, I explained, we talked about this situation before. When tournaments in California or Vegas have tournaments, it's called a tournament series. These series go from anywhere from the World Series obviously goes 60 days. Smaller series go 30 to 40 days. Some of them in California, some are 2 weeks. Some are 3 weeks, some are 4 weeks. So if they have a wide range of dates dating back, say, hypothetically speaking, 2015 or whatever, and I can prove that from 2015 to all the way to 2016. Basically, they're saying, I got proof that I was not in this state in 2014, basically.
The whole year.
Not the whole year. Not the whole year.
Okay, but that's what I'm trying to say to you, is that there haven't been any specific dates about 2014 where she has stated, this happened on this date.
Well, basically, they're saying that their case is based on 2014 when they haven't found any proof to even put me in the state of Nevada in 2014. There's no proof. But I have proof that I wasn't, and I got a witness that's going to say I was in California.
Okay.
So basically,
That's an
the
alibi
state-
witness, right?
Yes.
Was that person noticed as an alibi witness?
Yes, he's on there.
Who was it?
Fred Wolf.
Okay. Ms. Kollins, any representations to make in regards to this?
Fred Wolf was noticed by Mr. Mueller as an alibi witness. That was withdrawn. It was also stricken based on the fact that it contained nothing substantively. He gave me an informal witness list here in court. Again, there's no suggestion in that handwritten list that this person's going to testify to a specific date range and when he was out of town. No notice of the alibi was filed. That's my position.
And then, I'm sorry, in regards to these records about 2000,
Well, it's kind of difficult because I don't know what he's referring to. I mean, he's talking about some poker tournaments, and then he's talking about other documents that he wasn't really clear about. I agree with the court regarding, the poker tournament paperwork, but I don't know what other documents he's referring to, so if he wants to make a record, if he's missing discovery, if it's something that we can give back to him and duplicate for him,
sure.
then...
Okay, so let's talk about what exactly is missing.
I'm not missing discovery. I'm missing my, also.
No, we're gonna stay on topic.
Okay.
What are you missing?
I'm missing flight tickets, I'm
Okay.
missing car
Okay,
rental.
flight tickets. From where, when, to when?
From the airport here to LAX, from the airport here to Long Beach, I'm missing that stuff.
Okay,
I
when?
can't- It's from 2014.
Okay, and it's showing you're gone for how long?
Well, it don't show, then it shows a rental car. I got a rental car with Hertz. I would go in leave Nevada, fly leave Nevada, fly into LA. I need a car in LA because the tournaments are a different stop. And also, when you talk about tournaments, if I go to LA, I wouldn't go for one tournament. I would go there and stay 2-3 months.
Okay, but how are you gonna get any of that in?
Well, I can't get it in. How am I going to
If
get
you
it in?
had it, yeah, if you had it, how would you get it in?
Well, Fred's going to testify.
Okay, but Fred can't testify to documents, okay? So do you have a custodian of records for the hotels, for the airport?
Yes, I can get that.
Okay, so this is the problem, sir. You haven't notified, you haven't noticed any of those individuals. So if I want to get a hotel record into evidence, I have to have a custodian of record from that hotel to lay a foundation that say, I'm the custodian of records, in my ordinary scope, of course, of my business, I keep these records. This is a record, this is a fair and accurate depiction of this record, and then it's moved in. So I'm trying to understand how you were going to get these documents in. Now, a person like Fred, if he comes in and says, oh, I was with him on these dates, that's a little bit different. But Fred can't bring in documents, just like you can't bring in documents.
Fred's not going to bring in documents.
You can't show Fred a document and then that document come into
Okay,
evidence.
I understand.
So I'm trying to understand exactly what documents you felt you were missing that you were going to be able to bring into evidence in this case.
Okay, I guess, Your Honor, what I'm trying to say here is the DA, Stacey Kollins, has been put at a really good advantage.
Okay, no, that's not what we're talking about right now. I need you to explain to me what documents are missing.
I just told you.
Okay,
I
so
just said
plane
tournament
tickets?
records, airplane receipts, and car rentals. I had it all.
And where did you get those?
Where I had them. I never throw away nothing. I keep all my stuff from years ago. Even this stuff, mail, I keep it from years. I never throw away hardly anything.
All right.
Just for my taxes and stuff like that.
And so you had proof that you had flown to California in 2014 and rented a rental car.
Yeah, I'm
two
pretty sure
times, correct?
it was Hertz.
So
Hertz and Enterprise.
So 2 flights to California and
Well-
two rental cars?
Yeah, sometime I drove, Your Honor, but sometime I drove to California. It depends on,
Yeah, no, I get it.
And I didn't look at the date of the rental car. I didn't look at the date of the flight. I just know that I had flight tickets and rental cars.
Okay, but if you can't tell me that these documents are so important and then tell me you don't know the dates.
I didn't look at the dates of none of this stuff.
Well, is it 2014?
I just brought in everything, even these. I don't know what year they are.
Okay,
I
so
just
you
brought
have no idea what document. How do you know what documents you're missing if you can't even tell me what the documents look like?
Your Honor, I know the car rentals. So,
But you don't know what year.
well, I would assume that.
No, we can't assume. Do you know what year?
Your Honor,
No. Yes or no? Do you know what
no, I
year?
don't know the exact year.
You just told me, sir, this is why I get a little bit frustrated with you. You just told me that you were going to present documents to this court and to this jury that would prove you were not in Las Vegas in the whole year of 2014.
I didn't say the whole year.
I just asked you if you knew what year plane tickets were for and the rental car, and you told me you don't know what year. Do you see how that's frustrating?
Your Honor, I'm pretty sure it's 2013, 14, or 15. They're all from that year. All from those years. I cannot pinpoint exactly what year I put in it. All I know is I went in my records and got every year like
Okay,
this.
then how do you know it's missing?
Because I don't have it here.
So it's in an envelope like that.
No. This is, see, basically grabbed everything. If you look at these, this is 2014. This is 2015. And I baked 2016 here.
Can I see one of those
Yes.
mental Kelly, please? Because I can't see it here. Okay, so basically what I'm seeing, what is in front of me are Eastgate, these are all
Yeah, those I still have.
envelopes from Eastgate Apartments.
Right.
Eastgate.
And
Hold on, Eastgate. 2 letters from Metro, 1 letter from Eastgate. None of these have ever been opened from Eastgate.
and there's a reason we have
Okay,
to
I'm
know.
just making a record. So nothing's been opened from Eastgate. And then there's 2 empty envelopes from Metro. These are February of 15 and April of 15. The envelopes from Eastgate are 2015, 2017, 2014, one that I can't read, 2015 and 2015, which are all bills of your lease for your apartment in Las Vegas for the years 2014, 2015.
Yes, Your Honor, the relevancy of that is they weren't open, these letters are not open, and I got more. They're not open because I was not there to open them. That's why they have never been open. So, I was in California, they were never open, and I got all kinds of letters and stuff like that that hasn't opened, because obviously if I'm in California, I cannot open my mail.
So how are you going to get those into evidence?
I guess I'm not. But, Your Honor, so basically, I'm saying the DA, Stacey Kollins, has had an unfair advantage. First off,
Okay, wait, hold on. We have to do things. You wanted a mistrial because of what? Because of you're missing,
missing documents.
and what you're missing is we talked about 2 flight receipts and 2 car rental receipts. You're not sure of the dates, but that show you were in California, correct? I just need you, when I
Right,
ask a
correct,
question, yes or
correct,
no.
Your Honor.
I have that part correct, right?
Right.
But you never noticed a custodian of records for either the car rental company or the airline to get those records in. Is that correct?
Right.
Okay. So your motion for a mistrial, I need you to lay a legal foundation for me why you believe a mistrial should be granted.
Your Honor, I think with the crime, the charges I'm facing, I think every document is very important. If I can show where my whereabouts is in California, or the most important thing wasn't the flight, wasn't the car rental. I think the most important thing was my internment records, which I can produce so many internment records. It would put me in California in 2014, basically 7-8 months.
Okay. And how were you going to get those in?
I was going to give them to the DA this morning. I got a file right here with her name on it that was, although she don't talk to me or nothing like that, or I can't send her things, but I did. I'm not sure where I did that.
So the issue is, sir, we are now beginning our 2nd week of jury trial. You cannot hand the district attorney a bunch of documents in the middle of trial. wish to call a witness who will discuss you being in California in and out in the terms of 2014, obviously I think that that's something that you can do. But in regards to documents, I'm still trying to figure out what documents you believe were coming in. You told me that if I went on the internet, when we were talking about something in a previous calendar, you stated, Judge, if you were to go on the internet and you were to Google, you would be able to see all of the tournaments that I've been in and what dates they were.
You will be able to see the ones you cashed in. They don't show losing ones. So say if I play a tournament and I don't make the money, I make nothing. So say I put up my $1,000, I play the tournament, but I don't make it to the end. They won't show that. So say if I play a tournament and then I make it, say it's a $500 tournament, and say I make $2,000, they will show that.
So if I Google right now, it's not going to show me all the tournaments you've been in?
No, it won't show you every tournament. It will show you only the ones I cashed.
Okay. So,
But tournament directors keep records of this tournaments. So say if I'm at the Bicycle Casino in California, or even the Venetian, if I enter a tournament, tournament directors keep records. They know who entered their tournament.
okay. And then,
And we are given a receipt.
and then yeah, those tournament records that you had showed that you were in various tournaments in 2014, right?
Right.
So my questions for you is, one, that's definitely going to show that you were in and out of California over a period of time in 2014, right? But since the alleged victim, Vanessa, never testified to specific dates, help me understand, like, the relevance of that.
The relevance of that, Your Honor, is I got Fred Wolf that he's been my key witness because I never had a place to stay in California.
Right.
If you looked at the sheriff thing, his address is on there. I had a key to his house. Whenever I went to California, I stayed with him. Now, sometimes I play a tournament overnight, and I would just crash at a hotel or whatever. But I stayed with him. The reason I stayed with Fred Wolf for so long is I was part of his family, basically. He used to keep foster kids. So
I understand, but try to keep on the
right. So
dates,
so I stayed at his house, and I was given a key. But the reason I was in California in 2014 so long is because his wife, Pauline Wolf, was dying of cancer. And he basically needed someone to help, stay around, support. Fred at that time must have been like 81 or something like that. Now he's 86. He was unable to drive around to the casinos and everything, so I helped him with yard work. Obviously, I came and went as I pleased. I stayed. Basically, I had my own room. I had my own key.
Look, stay on. If you wouldn't mind, if you could please just stay on my question, because my question was, when a victim doesn't give you a specific date, basically what you're telling me is Fred's going to testify to all that, right?
Yes.
Fred's going to say he was in California all the time because I was sick, or his wife was sick, and you were helping him out, right?
Right, his wife was dying.
So let's leave Fred out of it for a second. How were you going to get the tournament records themselves into evidence?
Well, I was going to, just today I was going to put them in.
I know, but tell me how. Walk me through how you were going to get them in.
Fred plays his tournaments. He plays poker like me. You know, obviously he's not really good, but he can say that, he would say that, yes, we drove to this tournament together. We went here together. We ate here together. Basically, you got a guy that will say, I was at this point in time, I was in this state. That's why I knew I didn't do this. That's why I knew it was all made up. Because, Your Honor, also, getting to the Facebook, if you look at the Facebook records that they search, the search warrant, you would never see anything in there from 2014.
I know, but we talked about this. Let's stay on topic, okay?
Yeah.
Let's talk about Fred. So, Ms. Kollins, do you have any representations to make in regards to Fred and the records about the poker tournament?
The court is accurate that none of that has been turned over to the state. I don't see the legal foundation to get those documents in without a stipulation. I mean, if Fred is going to come in here and say, You know, he was in California for all that time. Obviously, that's unwitnessed, that doesn't necessarily lay a foundation for the document, so I mean, it doesn't rise to the level of a mistrial as long as we're clear that those are the totality of the documents that he's alleging have been misplaced or.
Right, so the poker tournament records, as well as what we talked about before, the 2 flights and the rental cars, correct?
Yes, Your Honor.
Okay.
I don't know how many flights it was. It could have been more because, you know, I mean, it's a year of window or whatever the
Well, it's
prosecution
maybe
got.
a year, because you don't know what year it is. You've already said multiple times you're not sure what year it is.
Well, I know that in 2014, I was flying.
I literally,
Well-
I literally asked you 3 times, and you told me 3 times you don't know that.
2013, 14, or 15, that's what I said.
I respectfully feel like you change your story multiple times to fit whatever's happening. It happens almost every single day that we're
Your
getting here,
Honor.
and it's frustrating when I'm trying to make a clear record, sir.
Your Honor, I said 2013, 2014, 2015.
No.
I didn't say one specific year. Also, Your Honor,
Just so Miss Collins, you've never seen these documents, correct?
No, ma'am.
And so are you stipulating to the existence of these documents, or you have you've never even seen these?
I have never heard this before today.
Okay. So it's the defendant's claim that he had all of this and that it's all gone missing while he was at the jail. I will represent that on Friday, he did have the opportunity to go through everything while the CO was here, and he went through all the documents and he didn't state anything.
nothing was missing Friday, Your Honor. Nothing was missing Friday. It's when I got taken back to custody, stayed another 12 hours I never said nothing was missing Friday. All my documents, I said maybe I left something in the car, but then I thought, no, I didn't leave nothing in the car, I got it all up. I didn't state anything was missing Friday.
Okay.
When I got taken back into custody, after my court date, when they took me down and you had me released,
Right.
I was locked in a cell 12 hours until they let me out. That's when my documents was unsecured, on a locker. I basically got out of jail. I didn't sit around and check. I was checking in the jail, they wouldn't allow me. I got home, and that's when I noticed the documentation missing. Now, Your Honor, with a case like this, I think, I should have all the documents possible to defend myself. So if anything was missing on the prosecution side that they think is relevant, she would want it. So why can't I have my documents?
I'm sure she would, and at this point in time, if it was the second week in trial and she had never turned them over to you, I would tell her, sorry, that's against the rules. So,
Have house arrest calling me back, Your Honor, that's where the lockers are located.
okay,
That's what the lockers are.
just 1 second, Miss Collins, I'm looking up something really quickly. All right, sorry, go ahead.
Were copies of these items given to Mr. Mueller's office when you gave him your alibi witnesses?
No, all I gave him was an alibi. I fired him a long time ago.
Well, you fired him a couple weeks ago.
No.
You fired him like a week before trial started.
No, I didn't.
I was on the phone with
Your Honor, I fired
you
him.
in his office,
I
you and Miss
fired-
Collins.
When I was on the phone with you and Mrs. Kollins in his office, I had fired him. Okay? He put in a motion for me to come to court. He says, I'm trying to move it up. And they tried to have me retain them. I refused to retain them because they refused to do any work. Felt like I was paying for nothing. So I said, I'd rather go to court alone. First, I went to Kelsey Bernstein. She said that she could take this case. She's familiar with Mrs. Kollins, but she said she would need some time. I advised her that I will not give 7, 8 more months sitting in an ankle bracelet while I suffer.
Okay, so,
So Your Honor, when documents are taken, go ahead.
So let me get this right. He wants a mistrial. What does he think? We're just going to start over on Monday? You know,
Yeah,
he's
hold on.
taken I'm sorry, I'm talking, Mr. Davis. He's taken every opportunity to destroy the record in this case. I mean, if he wants to, if the court is satisfied with his motion for mistrial, if you want to remand him, call a mistrial and appoint him a lawyer, the state is fine with that, honestly.
All right, so pursuant to pursuant to discovery obligations by both parties, NRS 174.245 discusses disclosure by defendant of evidence relating to defense, and it discusses the types of evidence that should be disclosed to the prosecution. The prosecution owes that same duty to the defense. Handing over documents that we still have no proof ever existed, or if they did exist, what they are of. In the middle, we are in the second week of trial. The defendant's motion for a mistrial is denied. I'm still not satisfied that these documents existed. If they did exist, like I stated, we're in the second week of trial. This is the type of evidence that should have been disclosed weeks, if not months ago. Secondly, the defendant has not noticed one witness that would be able to bring these in. There is not a custodian of records for a plane, an airline company. There's not a custodian of records for a rental car company, as well as these alibi witnesses. I mean, basically what Ms. Kollins is saying, at this point in time, she is so frustrated by what's going on that she's willing to let Mr. Wolf come in and testify as an alibi witness, even though the proper alibi witness filing wasn't done. So the defendant's motion for mistrial is denied.
Okay.
We cannot continue to be doing this. It's 1:30. Every time we come in here, this jury sits for hours. What else do we need to handle before this jury comes in?
Your Honor, I want to put in a motion to draw out the testimony of Vanessa Robinson. It's plain.
Okay, if you'd like to file that, you may file that, and I will give the state an opportunity to respond. That will be filed in open court.
Right. I filed it downstairs.
Oh, it's already filed, great.
And it's plain to see that the court saw it, but the inconsistency.
Okay, so
of
no,
the
we're not
statement.
hearing that right now. Just because it's filed doesn't mean we start hearing it. So, he stated that he filed it downstairs. Is there a file?
Yeah, it's already.
All right, and has it been served upon the state?
Before we keep going,
Yeah,
where did these documents come from?
Hmm?
the defendant.
We don't take your, they've all been filed under.
Okay,
So can we hand them back to him, because we can't keep taking these documents?
sure. So those have been filed. They should be updated in the Odyssey. Ms. Kollins will have an opportunity to look at those and respond. Anything else before I bring the jury in?
Yes, I want to file for prosecutorial misconduct.
Okay, did you file that downstairs?
Yes, I did.
All right, so we'll have a copy of that.
And I want to file a motion for you, Your Honor, to recuse yourself from this case.
Okay, that's already been decided by Judge Jones.
That was a different one. This is a new one.
Based on what?
Based on to the heightened risk of unfair trial, I'm asking you to recuse yourself. The simple fact is that I was thrown in jail. My rights to a fair trial was hampered greatly by you having me put into custody.
Okay, I'm sorry, sir, that's not a motion for recusal. If you're saying that your motion for recusal and you asking for something to happen because you went to jail for a few days are two different things.
Your Honor, so I got 10 pages of this, and in order to defend myself against a case like this, it's hard to do it when you are stripped of your ability to go to the law library, you're stripped of your ability to use the phone, you're stripped of your ability.
Sir, you were there for 24 hours.
Wrong.
Less than 48?
I'm willing to bet on that too.
Okay.
It's no way I was.
So you want me to recuse myself because you went to jail for 48 hours?
Your Honor, it greatly hampered my case, and it gave the DA a very uneven. It made this playing field very uneven.
Okay, was that filed?
Yes, it was.
Okay, thank you. It's noted for the record.
I also filed, the grand jury indictment is beyond the statute of limits.
Okay, you filed that 3 times already, that's noted for the record.
No, this is the first time it's filed, Your Honor.
No, you filed that multiple times. Motion to dismiss for the statute of limitations being ran. We've discussed that over and over and over again.
Yes, you never gave me an answer on if this case is past the statute
Sir,
of
yes,
limitations. You told me that you would.
I explained to you very politely multiple times that that is a sufficiency of the evidence argument. That had to be put in a what? I know you know it because you said it last week too. What does it have to be put in?
What does it have to be put in?
Yeah, if you wanted to file that, it had to be filed as a
Affidavit.
petition for writ of habeas corpus. I asked, would you like time to file a petition for writ of habeas corpus and we can continue this trial out? You stated no. So I've already ruled on this multiple times.
That was different, Your Honor.
Okay, all right, so it's filed, noted for the record.
Yeah, also, Your Honor, this is double jeopardy. I asked if this case is dismissed due to double jeopardy. This
Okay,
is the
and have you
same.
filed it?
Yes,
All
I
right,
did.
noted for the record, thank you.
And I asked this court to call this trial a mistrial due to the simple fact is, when I went to trial, I was stripped of my ability to defend myself because I came from a holding cell. I had no time to prepare the night before.
Do you acknowledge that we offered you additional time and that you chose not to take
No,
it?
no, this is the other day.
Yeah, I remember.
I was offered more time for what?
On Friday, you were offered more time for your opening statement. You stated no. You were offered more time to prepare your cross-examination. We said we would continue the trial until Monday, and you said no. Do you remember both
No,
of
I
those?
don't remember that.
Okay, well, the
I'd
record
like to
will
see that on the
reflect it.
record, because that was not an option. I would have automatically took
Ms.
it.
Kollins, do you have anything to say?
Because of the concerns he expressed on Friday morning, I offered him time to prepare an opening. He refused it. I offered him time to review his paperwork regarding cross-examination from Ms. Robinson. He refused it. He said he would just go forward anyway. And I think even the court reiterated my offer. I don't have a reel-to-reel in my head, but I know I offered him more time on both grounds.
I was never offered any time. If you said, if this
The
court would have
record-
said, okay, we'll give you a day to get out of jail and to go home and get your situation, everything straight, I would be an idiot not to take it. I was offered nothing. I was taken from jail and brought to this court with all my stuff messed up, in my jail clothes and all my stuff, no sleep deprived, no access to the law library, no access to the phone. So obviously, I would have said, I'll take it.
Okay,
I
the
would
record
have
will reflect what happened.
So the court saying that I was offered that
I
is
can
not
tell
the truth.
you, looking at you 110%, I said, sir, do you need more time before you give your opening statements? You said, no, I want to go right now. When Ms. Kollins was done, I called you back up, and I said, would you like more time? You said no. Then, when you stated that you couldn't be ready for the victim, I said, we'll start with Ms. Kollins, and then after she's done, I'll give you the opportunity. You said, nope, I don't want them to be all weekend just in what she said. I want to go right into it right now. That's exactly what happened. The record will reflect all of that. I'm 100% positive.
Yes, the record would reflect it. More time isn't saying, you never said, okay, you can have a day and come in Monday fresh and have everything ready. This court has been rushing this case from day one. It's been rushed.
All right,
Mrs.
your
Collins,
motion
DA
is denied.
Okay.
Call the jury in, please. We are not
DA,
getting this
Mrs.
anymore.
Collins has been given a great. Just want to make me defenseless.
Just ask the court that you reminded me of the one last week.
In regards to the comments,
Yes.
all right. So in front of the jury, there will be no comments except for questions towards the witnesses and objections.
Entrance to the jury. All members of the jury are present, Your Honor.
Thank you. Good afternoon, ladies and gentlemen. We are back on the record. In C-342946, statement of adverse Raymond Davis, who is present with his standby counsel, Mr. Klaus. Chief Deputy District Attorney, Ms. Kollins, is here on behalf of the state. We're still in her case in chief. Because of some scheduling issues, we are actually not going to be continuing with Vanessa at this point in time. Ms. Kollins will be calling her next witness, and then we will return to Vanessa tomorrow afternoon. Ms. Kollins?
State House Detective Art Martinez.
Your Honor, that wasn't the order given. He's supposed to be the next witness.
Good afternoon, Your Honor. Can you stand? Please raise your right hand. You solemnly swear the testimony you're about to give this action will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You may be seated. Please state your name, spelling both your first and last name correctly.
My name is Arturo Martinez. It's A-R-T-U-R-O. Martinez, M-A-R-T-I-N-E-Z.
Good afternoon, Detective. Thank you for your patience. Could you tell the ladies and the gentlemen of the jury how you're employed?
I'm employed through Clark County. I'm with the Las Vegas Metropolitan Police Department and currently a detective with the Sexual Assault Unit.
How long have you been employed with Metro?
Approximately 17 years.
And how long have you been assigned as a sexual assault detective?
Approximately 5 years.
Tell us just a little bit, what does a sexual assault detective do?
Well, the duties of a sexual assault detective is to investigate any allegations of a sexual assault crime involving either adults or juveniles. Our job is to gather all the facts and present the case to the DA's office if it's going to go forward, or deem if it's something to investigate.
Turning your attention to July 23rd of 2015, were you a sexual assault detective?
Yes, I was.
Assigned to what division within sexual assault?
I was with the sexual assault detail swing shift unit. So that means we start our shift between 3 p.m. to 1 a.m.
Were you assigned any particular age group to investigate?
Not with that unit. That unit investigates all adult victims alleging of a sexual assault and all juvenile victims alleging of a sexual assault.
Because swing shift combines those responsibilities.
That's correct.
Are you familiar with a woman by the name of Esther Brown?
Yes, I am.
And who is Esther Brown?
I recall she was a counselor or somewhat of a therapist for the Clark County Juvenile Hall facility.
Are you familiar with her work with the Embracing Project?
Somewhat I am, because she had emailed me on her job duties.
On her letterhead, basically?
That's correct.
Did you receive information from Ms. Brown in July of 2015 regarding a Vanessa Robinson?
I did.
And what did you do in response to the information you received from Ms. Brown?
So on July 23rd of 2015, myself and Detective Shane responded to the Clark County Juvenile Hall Detention Center. We made contact with a female juvenile identified as Vanessa Robinson, who was 14 years old at the time. Prior to our arrival, we had information from Miss Esther, who reported to personnel there at the juvenile hall that Vanessa had disclosed about sexual abuse allegations involving another adult male. So myself and Detective Shane responded that day, and we interviewed Vanessa Brown at the facility.
Vanessa Robinson?
Vanessa.
I'm sorry, correction, Vanessa Robinson.
Is there an objection, sir?
Yeah, object, I don't know who Vanessa Brown is in this case.
I think the correction was made. Objections overruled.
There is no Vanessa Brown in this case, is that fair, Detective?
That's correct.
You interviewed her, did you record that interview?
Yes, I did.
Was Vanessa in custody at that time?
Yes, she was.
Do you know what she was in custody for?
I don't recall what she was.
Do you know if it was a probation violation?
I believe in her statement she had mentioned that, yes.
Um,
I
After,
object, Your Honor. Can we, I mean,
What's your objection, sir?
she asked him, does she know what she was arrested for? Obviously, the detective would know.
Okay, so do you have an illegal objection, or I can't do speaking objections, but if you have a legal objection, I'm happy to hear it.
Yes, his statement is basically saying he didn't know what she was in jail for. If he's a detective, if you go
Mr. House,
interview.
would you mind just speaking to me briefly about a legal objection?
So I would just like the officer to clarify, I mean, either look through his records or whatever, we can find out why she was in jail and just saying robbery or probation or whatever violation. So,
Go ahead.
yes, it's okay.
Okay, so the objection is
Withdraw.
withdrawn at this time?
Withdraw.
Okay, thank you. Please proceed, Ms. Collins.
thank you. Did Vanessa give you a name of the person that she disclosed sexual abuse about?
She did.
What name did she give you?
She gave me Raymond Davis.
Did you know who Raymond Davis was when Vanessa gave you that name?
I did not.
Tell me what you did to try to discern who she was identifying.
I asked for a description for Mr. Davis during our interview, and she described older black male adult with no hair on his head, and stated he was probably in his 30s or 40s, and she had also given me a prefix number of his cell phone at one point in time during the interview, which started with the 562, and that's in an area where she believed he lived at, which was the area of Vegas Valley and Nellis Boulevard, I believe, in her interview.
So based on that, did she indicate to you whether or not she had any Facebook conversation with this person?
She did.
Did you review any of her Facebook information at that time to try to discern who Ray Davis was?
The only thing I reviewed was a name given for the profile that she had, or the name given, which was a profile that she had provided at that time.
Did you, once you
Yeah,
gathered...
I object, Your Honor. Can we go more into that? I don't understand what his answer was. That he investigated a profile. I just need more details of that.
All right, so,
I don't understand.
sure, so you can get into that on cross-examination. So the
Okay.
objections overruled.
Withdrawn.
Okay.
Withdrawn.
Given the area of town that you knew this person lived in, as well as the description that Ms. Robinson gave you, what were you able to determine?
I was able to find the exact location of Mr. Davis's residence and head over to the office and identify Mr. Davis through that means as well.
And what was that address, remember?
It was 3055 South Nellis Boulevard, apartment 2145.
And that is in the area of Nellis and, is it Vegas Valley?
Vegas Valley and Nellis, yes.
And that's here in Las Vegas, Clark County.
That's correct.
Did you confirm that, you said you went over to the apartment, did you go to the office, what did you do?
Yes, I went over to the office and They had given me the apartment number. I went over to the apartment, to Mr. Davis's apartment, to attempt to make contact with him and schedule an interview, and I had left a business card at his residence.
And when did you do that?
I believe that was January of 2016.
Between the time of talking...
All right, can I get that date again?
January of 2016.
Thank you.
Between the time you saw and interviewed Vanessa till you went over to Mr. Davis's apartment, what did you do in the interim?
I was attempting to locate a possible witness at the time, which was another female juvenile identified as Adriana Walker, and another juvenile by the name of China Rolls.
Were you able to locate those individuals in the interim between the July of 2015 and the January of 16 visiting the defendant's apartment?
I was not.
Did you compile a lineup?
Yes, I did.
And what did you tell me about that?
So after I identified Mr. Davis, I compiled a photo lineup, and I was having a hard time trying to find Vanessa Robinson. So I had finally located her, and they had given me a location at the Caliente Youth Center, and I had communicated with a Tyler Peterson there, who was personnel there, and I had gave him very minimal details of the investigation due to the fact that there's a juvenile involved and it's confidential. But I did request the photo lineup be completed with Ms. Robinson, and the photo lineup was mailed over to Mr. Peterson, and I'd say within a month I received the photo lineup back completed by Ms. Robinson.
Okay. And when was that?
That was around the same time frame, January of 2016.
When it was returned to you or when you sent it?
Both.
Did you cause the original of that photo lineup to be sealed and placed into evidence?
Yes, I did.
Showing you what has been marked as the external envelope is state's proposed exhibit 2. Do you recognize the exterior of that envelope?
I do.
How is it that you recognize it?
It has my signature, and I can recognize my own writing.
Does it also have an event number consistent with this case regarding Raymond Davis?
Yes, it does.
And did you cause that to be sealed and placed in the evidence vault?
I did.
Anything about the exterior of that package look like it's been mishandled since you put it in evidence?
No, it is not.
State would move for the envelope admission 2. You didn't, did we admit 2?
Okay.
I apologize, I thought I was admitted 2. If you could, inside that envelope, there are 2 separate sets of documents in there. If you could pull out 2A and take a look at that for me, Detective.
Okay.
Have you reviewed 2A?
Yes, I have.
Do you recognize 2A?
Yes, I do.
What is that?
That's a LVMPD photo lineup.
What's unique about that photo lineup and how do you recognize that particular one?
Well, this particular one has my writing on the bottom where it says officer's name and P number. It also has Ms. Robinson's name and information, and it has Tyler Peterson's name and information. It also has a photo of Mr. Raymond Davis.
And which photo in that, within 2A depicts Raymond Davis?
It would be the one that's circled and with the name of Vanessa Robinson on it.
Do you see Ray Davis here in court today?
I do.
Where is he seated and what is he wearing today for the record?
He's seated to your right, and he's wearing a green t-shirt with green, I believe they're green camouflage or military pants.
May the record reflect identification of Mr. Raymond Davis.
It shall, thank you.
Thank you. After you received the photo lineup back, did you cause a search warrant to be issued?
Yes, I did.
And tell me about drafting and issuing that search warrant.
After I identified Mr. Davis, I made a preservation for the Facebook company, and the warrant was executed, I believe, on or around April of 2016. I don't have the exact date, but it's around that time frame.
I want to talk to you about the drafting of that search warrant. Specifically, what items did you request?
I was looking for any communication with between Ms. Robinson and Mr. Davis.
Let's talk about the dates that you put in your search warrant. What time frame did you put in your search warrant?
I believe it was January 1st of 2015 to the present time, which would have been, I don't have the ending date, but it was probably May or April 2015.
Okay. Now, was January 1st of 2015 the correct start date for that search warrant?
No, that was not.
What would have been the correct start date for that search warrant?
I should have put January of 2014.
The information you had from Vanessa would have included 2014, is that accurate?
That's correct.
Your Honor, I object. Basically, Officer Martinez,
Well, I'm going to object. Is there a legal objection?
yeah, I mean, his dates, he just
Well,
admitted,
objection.
he just admitted that his search warrant was the wrong dates.
So if at any point in time there's something that you want to address with him on cross-examination, make sure you notate that down.
Okay,
But in regards to objection, it has to
I
be.
withdraw.
Thank you. Go ahead, Ms. Collins.
Based on information you had from Vanessa, should that search warrant have included Facebook information from January 1st of 2014 through April of 16, whenever you issued it?
That's correct.
Did you receive a return from that search warrant?
I did.
And tell me, when you ask for information from Facebook, tell me specifically what you asked for and tell me specifically what you got back, because it's a whole bunch of stuff, right?
Yes. For this specific case, I recall requesting the communication or messages between both. And with that duration of January 2015 to the present time that I requested it, also any contact information of said individuals in this case, any, I think you call them low geolocations of where they would have been at when the messages were sent.
So when you say the individuals in this case, just so we're clear, you're talking about Vanessa and Ray Davis, correct?
That's correct.
And how about Adrian Walker?
I did not request a search warrant for Ms. Walker's Facebook profile.
When you issued your search warrant for Facebook, so your warrant encompassed Ms. Robinson's profile, is that correct?
That's correct.
Mr. Davis's profile,
That's correct.
and that would include their contacts and any communications between them, correct?
Yes.
When Facebook sends you back all that information, is that just a couple, 3 pages? What kind of documentation are we talking about that the return for this search warrant entailed?
Well, it's a lot of information. I recall one of the profiles had over 1,400 pages that I had to go through and just extract the pertinent information to this case, because it includes all communication with other individuals, all pictures, all emails or phone numbers, And so it was a lot of information to bring out, and it also included information with communication that, in this case, Raymond had with Miss Adriana Walker.
Officer, if I could get you to get me, I think it's states 4 through 10.
It's just, so Marshall Kelly will walk them back and forth.
Run up the record to reflect and show in the screen. The data states proposed 4 through 8, been previously provided in discovery.
Okay, thank you.
If you could take those tables out, please. Detective Raymond.
Your Honor, I object to this. I would like to vote. Your Honor, plainly he says that he messed up his years. And that is a big one, considering he's given Facebook records for the years he didn't supposed to. I think if we want to see Facebook records, he should get them from 2014, because that's where supposedly this crime happened. Because the state is claiming that this happened to a 13-year-old girl. Well, if he gets records from 2014, Facebook records, that will show that I made contact with her, not a record that's from 2015, which would make her 14. So the state's case of her being 13, he can't prove it because he has no records. He's shown records from 2015. Yeah, I object to the 2015 records, Facebook records being used to convict me to try to convict me for a case that he says is supposed to be back in 2014. Because if you take the 2015 records that he has...
So I get your argument. Right. What's the objection? So is it hearsay? What's the objection?
Yes, hearsay.
Okay, so just explain to me. Tell me about that.
The officer right there just admitted that he had the wrong year, that he should have got 2014. If the state wanted a case, Your Honor, they should have went and got 2014 instead of bringing records for 2015 in the court. What did 2015 prove when I'm charged for 2014? Yes, they got to prove that that's my Facebook, Your Honor. And it hasn't been proven that that's my Facebook. I have one Facebook. It's Poker Star.
They're documented as a business record kept in the ordinary course to the detective. They come routinely through an email link. They no longer hard copy. Facebook doesn't. So these are a business record kept in the ordinary course of Facebook business. It comes like this and a link and an email. That's all it comes like. I asked him for it. There is no certificate that comes with it.
No custodial records affidavit, and the fact that they can get an IP address to match, but they have no IP address to match, and no custodian records, and they want to let this in.
Okay. So in the past, when I've seen your Facebook ones,
permission to look at it. I can put it on the record if the court wants me to. He told me that no certificate claim, that now when they do returns, because there's so many subpoenas, they do a link and an email, and this is on the deck. And I mean, the disc with all the records has the identifying information of each party. But there's no.
Facebook persons.
No.
You don't know. Stop talking.
Okay. So,
I mean, that's the only foundation we have.
so specifically right now with the question, you're trying to explain to me like the question that's going to go on with him in regards to these records.
You submitted a search warrant to Facebook, and how did that return come to you? That return came to me in an email with a link, or you provided any separate business certification other than that comes from their legal compliance division? No, I wasn't. And this is how they came, except there's probably like 4,000 pages of original disc.
So I think you can go into the questions with him in regards to what he did and what he received in regards to actual documents. And I do agree that it's hearsay without any type of affidavit or documentation. So I'm going to sustain that objection. But like I said in the question,
So the door has been opened by him in opening too. So when he opens the door about 2015, then I'm going to call a detective back, because we've heard multiple times in front of the jury, even during his opening, that Facebook's going to prove that I was friends with her in 2015. So he's really opened the door to them as well.
Your Honor, right. I take the rule, Your Honor. Right, I understand. Your Honor, what I'm trying to say is, I know I want an argument, but what I'm trying to say is, I want proof that this is my Facebook. It's not. Okay.
Yeah, I do.
all right. So sustain in regards to hearsay.
Thank you.
Detective, explain to me the process how you issue a search warrant to Facebook.
I have to provide the user profile names to Facebook or any personal information, which would include date of birth, cell phone information, maybe an address. And that's the type of information you have to provide them for them to actually confirm that that user exists with the company.
Did you do that for Vanessa Robinson in this case?
Yes, I did.
Did you do that for Raymond Davis?
Yes, I did.
How long after, when you submit your search warrant to Facebook, how do they respond to you?
They have a law enforcement portal that's specifically only used by law enforcement personnel, and when you first make the preservation for the usernames, they'll confirm that that username exists, and they will request that you submit a search warrant because it is a lot of personal information. And so in this case, the search warrant was, once it was approved, it was uploaded into the Facebook portal.
So when you upload your search warrant into the Facebook portal that is for law enforcement, are you communicating with an individual, or does it just go into this portal?
With Facebook, it's just the portal, so it's pretty much there at their pace, so you receive it whenever they...
object. Unless he works for Facebook, I don't know how he would know how Facebook operates.
He's describing his interaction with Facebook and his response times as a law enforcement officer. He is not giving an opinion on any internal workings of Facebook.
Okay, so for that purposes, I'll overrule the objection. Go ahead, please.
So when you log into this portal, how do you confirm that Facebook has received your search warrant?
I believe it's like an email they sent you, replying back to your upload.
Does that email come from an individual, or does it just come from the portal?
It just comes from the portal.
And when they respond to your search warrant, in other words, provide you what you're asking for, how do you get it? Do you get a big old stack of paper? Do you get a disc in the mail? What do you get?
In this case, they're just PDF files. So the PDF files, it's a link within the portal. So you just click on the hyperlink or the link.
I object, Your Honor. And we approach.
Yes.
Your Honor, I just won the ruling, and he's still saying what he got from Facebook as well.
I'm sorry, say that once again?
I just won the ruling, and he's still saying what he got from Facebook.
This isn't hearsay, this is procedural. There's no content being offered for the truth.
In this case,
Is it true that she can, I think that she can question him on how he went through his investigation, but she can't substantively get into what was in Facebook.
what about he's saying in this case?
So what right, so like if let's say he says, in this case I sent a request and within 14 days I received notice or something like that, I'm fine with that, as long as she doesn't substantively get into the record and say, hey, these are the records of what he has. This is who he was friends with. This is when he made contact with someone, so that would be substantive. So,
I guess he has a lawyer on. Well, I'm sorry, Mr. Klaus, if you're gonna lawyer for him, then I need to hear what you're saying.
No, I wasn't. I'm not trying to make the objection
Okay.
for him, Your Honor. I'm just trying to steer his objection on legal grounds rather than factual ones.
so,
So I'm sorry, I'm being parrot here for lack of a better term.
no, that's okay. So, go ahead, Mr. Dix, what were you saying? What was
Yeah,
the last
so,
thing you
so
said?
basically I'm saying what he's trying to bring in is evidence that's been taken out. Basically, he's bringing in how he got it, you know, this.
What I'm saying is that he can say, as part of my investigation, I received the records, but that's what it says. He can't get into what the record says, so he said,
Okay.
as part of the investigation, he received those,
Okay,
and then
I understand.
the junior person, what's actually in them, and they can
I
take them
understand,
as
yeah.
well.
Yeah, I understand.
Okay? So that objection.
Unless I can lay a business record foundation.
Yes.
Correct, okay. Detective, you were saying that you get them through a PDF. How is that PDF attached? Do you go to a website? How do you get to that PDF document?
So it's within the same portal that my work email is attached to the case. So they provide like a case number, and then they have a download link where you click on it and you download it to open up the file. And they come as PDF files, which is pretty much, looks like it's just scanned paper, and you go through each download they provide for you. In this case, they gave me three downloads, for 2 of Raymond's accounts and 1 for Vanessa Robinson's account.
Did they give you any?
Your Honor, I don't object, but did you say 2 Raymond Davis's? I just didn't hear him.
Yes, 2 accounts for Mr. Raymond Davis.
Oh, okay, thank you. Thank you, officer.
Did they send you any separate business record certification?
Not within those downloaded files. The only thing I have on top of the file on top of each piece of paper says Facebook business record.
And that's just a one line across the top of each piece of paper within the PDF.
That's correct.
There's no separate certification about a person to contact at Facebook.
There's not.
Have you received more than one Facebook search warrant return under the same circumstances?
For this case?
Not for this case, just overall. Is that how you always receive a search warrant return from Facebook?
From my experience, yes.
Have you ever received a separate business record document from Facebook in these search warrants that you've executed?
Not that I recall, no.
And the portal that you use to communicate with Facebook, tell me about who that's designed for.
It's all designed for law enforcement personnel.
Okay. Does that include state and federal law enforcement personnel? I mean, do you know any different way to get a hold of Facebook?
They provide a lot of phone numbers and addresses, but from my experience and through their guidelines at that time.
Your Honor, object. Object is called to the extent of, I object to speculation, to the extent of speculation. He's speculating on how it's done.
He said at the time in 2015, this is how it was done.
So if you know, your knowledge is fine, if you have personal knowledge.
Around that time frame, they provide guidelines on their website or within the law enforcement portal. And I have to provide them a work email, which in this case would have been Adam7775, M as in Mary, @lvmpd.com. And I don't know how they do it, but they confirm that you're a working entity with the police department, and they have you first request a preservation letter, and then they have you upload the search warrant when the link is provided at their, I guess when they decide to do that.
But they do not give you, or correct me if I'm wrong, do they give you any contact information for someone to certify that those are true and accurate records? Other than logging on through that portal, do you have any other mechanism?
At the time, not to my knowledge, I don't.
Did I have you go back and look for that certification?
Yes, you did.
Okay, were you able to find any separate document other than the Facebook link?
I was not.
State would renew my request to have the detective look and testify to the Facebook document.
I object, Your Honor.
Okay, and what's the objection?
On grounds of hearsay.
It goes to weight, not admissibility. That is the only foundation that we can lay for a business record for that time frame.
Okay, parties approach.
If we were just discussing whether or not it was actually his, right, everything to do with versus admissibility, because I think we argued in regards to the records themselves, self-employment, I just don't see how you get an endorsement checks without that affidavit that Facebook sends once they are subpoenaed.
Well, I mean, are they necessarily offered for the truth? They're really offered to show the existence of a relationship. I mean, it's not necessarily for just what's contained in them. I mean, he knows her, he's on her friend list, she's on his friend list. There's no solicitation in there. I mean, there's statements in there of come clean my house. But that's not offered for the truth. I don't care whether you wanted to talk to him or not. I mean, there is a non-hearsay purpose. I mean, I understand the court's concern. It was my concern last week. That's all I have. You know, I made him go back and look. I made him go call Facebook. There's nothing. So.
Your Honor, it's like you said before. I mean, this is basically hearsay. He just even mentioned that he got 2 different Facebooks for Raymond Davis. I mean, how do we know which one is mine? I only got one Facebook in this poker. So he searched 2 Facebooks. He said he came back with 2 Facebooks for me. To allow any, so basically, he don't know which one is me and which one is fake. So let's go ahead, Mr. Collins.
Go ahead.
Go ahead. So, if you had something to say, go ahead.
One of them is his poker stuff, and the other one is his personal. So.
No, okay. Well, I want to answer this, but I don't know how one is poker and one is personal. My poker, I mean, it's, so, Your Honor, to allow something in that's not even authentic, might not even be mine. It's hearsay.
So, I think the issue here is, yes, the issue isn't being offered for the truth of the matter asserted. I think it's being offered to show hey, these two were friends during this time period, right? So I do think it's offered for the truth of the matter asserted. I think the only way that it can come in is if Facebook obviously is personally subpoenaed,
Yes.
and then, obviously, when they send in their own affidavit via electronics, not Facebook to the attorney via, when they don't want to come in via their testimony.
Mhm.
That's,
I agree, Your Honor.
Okay, so again, he stood up 3 times and talked about what's in Facebook, so.
right, so if that door is open,
Well, I think it's already open as well.
so,
And openings are not legal arguments or facts.
so, the
Well, they are if you make suggestions about evidence that you can't argue.
Not when you got a time frame that don't match.
okay, so if you have, just so you know, if you have, I agree with Ms. I agree with Ms. Kollins, if that door is open, then the doors will be open. I agree with you that opening statements are not evidence. So, for right now, the objection is to hearsay is sustained.
Thank you, Your Honor.
Did you catalog what you received back from Facebook?
I did.
And did you provide that to the state?
I did.
Did you submit that as part of your request for an arrest warrant for Mr. Davis?
I did.
When you, after you got the search warrant returned from Facebook, and you had the photo lineup from Ms. Robinson, did you talk to anyone else?
I did.
Who did you talk to?
I located Adriana Walker and scheduled an interview with her August of 2016.
Did you also show Ms. Walker a photo lineup?
I did.
Is a copy of that photo lineup contained in States 2 that's still up there with you?
Yes.
If you would pull that out for me, sir, please. Have you take a look at 2B?
Your Honor, I object. This is basically hearsay. Mrs. Walker has not testified.
Well, I haven't moved to admit it yet.
Overruled.
Do you recognize that document?
Yes.
How do you recognize it?
It has my information on there, my name and my personnel number for the department, and it has Adriana Walker's information on there as well.
Your Honor, I object. Withdraw.
Okay.
Does it also have the event number attached to this case, 150723-4414?
Yes.
And what, without telling me what's contained in 2B, what is that generally? What is that document?
That's an LBMPD photo lineup.
Did you compile that photo lineup?
I did.
Does it contain a picture of Raymond Davis?
It does.
And you showed that to Adriana Walker?
Yes, she circled it and...
So tell me what she said.
Sorry.
Object, Honor, it's hearsay. Adrian Walker has not testified.
That's an observation. You didn't say what she circled or what she said.
So
It's not a statement.
the objection is sustained. I will note that he didn't discuss, we're not gonna talk about the contents of the document,
Okay, Your
officer. So just go ahead and silence.
You interacted with her with that document in your presence, correct?
I did.
And then did you ultimately take it back and deposit it in the envelope too that we talked about earlier?
I did.
Okay. After you talked to Adriana, after you did your work with Facebook, at some point did you make a phone call to Raymond Davis? Talking about January of 2016.
January 2016, I did, around that time frame, I did make a phone call to Mr. Davis, or actually, Mr. Davis made a phone call to me because I left my business card at his address.
And just specifically to this question, did Mr. Davis indicate whether or not he knew Vanessa Robinson?
I object, Your Honor, hearsay.
Statement of the defendant.
This is directly impinging against my, it's not.
I'm sorry, what?
It's not impinging on my penal interest.
Well, I disagree.
So it's a statement of the defendant who's not hearsay, so it is overruled when you answer the question.
What did he tell you about knowing Vanessa Robinson?
He did not know her.
When, just backing up just a little bit, when you interviewed Vanessa Robinson in July of 2015, did you take any efforts to get her out of juvenile detention?
I did not.
Did you interfere or intervene at all with the case that she was on probation for?
I did not.
Were you ever able to locate China Rowles?
I was not able to locate her, no.
Did you also talk to a woman by the name of Cecilia?
I did.
When did you talk to Cecilia?
I believe it was earlier this year, around May of 2019.
And did she provide you a Facebook post?
She did.
I'll pass the witness room.
Mr. Davis,
May I have a short break before Davis, Your Honor?
yes. Short as in you need a recess, or did you just want to step outside for a second?
Short as in all this stuff, just step in the antechamber with the court.
Just take 5 minutes, do you mind?
Yeah, that's fine. All right, during the recess, you're not to talk with the person by yourself or with anyone else on any subject connected to this trial, read, watch, or listen to any report or commentary in the trial of any person connected to this trial by any media information, including without limitation, newspapers, television, internet, radio, or format express any opinion on any subject connected to the trial that places filing submitted to you on file.
All rise for the ex jury.
About what?
Cross-examination.
Oh.
Examination is detective.
It's in process of elimination. Very well.
All right, the answer to the jury. All members of the jury are present, Your Honor.
Back on the record and stating the matter of Raymond Davis, that would be C-342-946. Mr. Davis is here to stand by counsel as the prosecutor, Deputy District Attorney Ms. Kollins is here. Detective Martinez is on the stand, so I just remind you that you're still under oath, sir. Thank you. Do both parties stipulate to the presence of the jury?
Yes, ma'am.
Okay, thank you. All right, so Mr. Davis is your witness at this time.
So, Officer Martinez, what was the dates of this alleged crime? You put it in your points of authority.
Can you repeat that again?
What was the dates that you said these crimes happened? That you put in your points of authority? I can bring it to you so you can look at it.
Yes, please.
Your Honor, he's showing him a state's motion. That's not drafted by the detective.
Well, I want to give him the dates that he can take a look at it.
Okay,
Well, objection, hearsay.
so that's a document that was prepared by the state?
Yeah, it's by the state, so, I mean, the state, this is the charging paper, so.
The objection sustained.
So, in your mind, what was the dates of this alleged crime? I'm not gonna give you the state's date.
It was 2014, on or around the, I think, fall or summer of 2014. And the other incident was early June of 2015.
You're saying June of 2015, you sure? it's
I'm
not?
sorry, correction.
Yeah.
It's June of, that's correct, June of 2015.
So, you acknowledge that you went and got the wrong Facebook search warrant. You acknowledge that?
Yes.
So, what I don't understand is, if you went and got the wrong Facebook records, why wouldn't you go back and fix that?
In this case, when I reviewed the Facebook records, I had seen that they were friends as of, I think, May of 2015. There's a specific date that it showed they are now friends. And so it was an overlook on my part because I had, for some reason, thought that that's the times that I requested were the accurate times, which I now find out it's not.
Again, officer, I ask you again, why didn't you go back and get the correct records when you had 3 years?
I did not. I found out recently.
So you just found out recently it was wrong.
Yes.
So, how long have you been a police officer?
17 years.
And you just recently found out that you got the wrong search book years.
Yes.
Wouldn't you go to the DA and say, I'm sorry, I got the wrong years, this couldn't happen in those years?
I had mentioned it to the district attorney's office during our discussion about the investigation, and I did tell her that it was an error on my part.
So basically, you told the DA that you err it. It's an error on your part, and they did nothing, they just moved forward?
I didn't do anything.
Right, I agree. So they just moved forward on it, you said?
Well, objection, speculation as to what the district attorney's office did with that case.
So,
So you told, so my understanding is you told the DA that you erred in the dates,
That's correct.
and which is, seemed like the right thing to do. So basically, so basically, officer, your knowledge of Facebook records, you wouldn't have none in 2014. Am I correct?
I don't have any Facebook records for the listed profiles for 2014, that's correct.
Basically, you only got from 2015. And how many search warrants did you obtain?
Just for this case, sir?
Yes, yeah, yes, officer.
Just one.
You only retained one Facebook search warrant?
Yes, just one.
Can I bring this to your attention?
I don't know what he has.
okay, could you show me this column, please?
That's fine if he wants the detective to look at it.
Yes.
It's the front page for the application of search warrant that contains all the requested information.
From Facebook?
Yes.
Okay.
Okay?
That's not one, is it?
It's one whole warrant. Yes, it is.
One whole warrant? How many people was on that warrant, officer?
This warrant encompassed 3 user profiles.
Can you name those three?
It's a Raymond Davis and a poker star Raymond Davis and a Vanessa Robinson.
So you have one Raymond Davis, you have one poker star Raymond Davis, and then you have one Vanessa Robinson.
That's correct.
Have people ever made fake profiles? To your knowledge?
Objection, speculation, relevance.
In regards to this speculation as, if you know.
If you know of it, have you ever heard of anybody making a fake Facebook profile?
I don't have any information to, I guess, to prove that they have, if anyone has.
So you can't prove if anyone made a fake Facebook profile?
I apologize, do you mean in general or do you mean
Right, in
this case?
general.
Okay.
No, I can't show if someone, I can't show if someone has a profile, if it's real or fake, I don't know.
I agree. So you wouldn't know if these profiles are real or fake?
For these specific profiles, the information that I provided to Facebook was the information related to my investigation. They returned the information that I guess received to confirm that they're linked to these usernames.
Officer Martinez, are you familiar with IP addresses?
I'm somewhat familiar.
Somewhat. Did you go get an IP address on these Facebook accounts?
I did not.
So you're somewhat familiar with IP addresses. So can you explain to the jury what an IP address is?
An IP address is, from my experience, it's a set of numbers that's given that gives you, that's tied into a Wi-Fi or a tower connected to the person using that, how can I say, internet service or stream. And so, for example, your Wi-Fi at home has its own specific IP address that is solely assigned to you through your service provider. And sometimes the IP addresses could be a guest, like a Starbucks has a guest Wi-Fi, and that has a specific IP address for that location.
So basically, what you're saying, Officer Martinez, if you would have went and got IP addresses, you could have pinpointed whose Facebook that was. Is that true?
Objection calls for an opinion beyond his expertise.
Your Honor, is showing that he could find out who Facebook this is.
So I just need you to, the objection is sustained, and I just need you to lay a foundation on what regards to whether or not he has that knowledge of how to do
So,
that.
do you have the knowledge, ability to match an IP address with an address?
It's not in my expertise. It's not in my expertise, so we have a specific detail that I guess are experts in doing that.
So you have someone in-house that could have, a police officer that could have matched the IP addresses and found out exactly who the user of these Facebooks was.
Well, objection, it's beyond his expertise. I mean, IP addresses versus who's using and bumping on an IP address, I don't think he has the knowledge base to.
Do you have any independent knowledge to answer those questions yourself?
I don't, Your Honor.
Okay, so the objection as to speculation would be sustained.
Your Honor, what he's saying is his department.
Okay, I understand what he's saying, but the objection is sustained.
So, get back to Facebook. So, you only found out that your dates were off from 4 or 5 years ago. You found out recently. How recent was that?
It was in preparation for this trial, is when I observed the error.
Can you tell me the date you observed this error?
We've been preparing for this trial I've been preparing for this trial for quite a bit, so I would say, safe to say before September of this
past September?
The first set date was September 9th, so in preparation of this probably over the summer of this year. Sometime, I don't have a
You
specific
found
date.
out over the summer that your address is which
I
one?
don't have a specific date, sir.
And you informed the DA that the dates were off.
That's correct.
And what year did you go get the arrest warrant to arrest defendant Raymond Davis? The defendant?
When I issued the warrant,
Yes.
September of 2016, I believe.
So, my question is, if you went and got a warrant from 2016, and we are now in 2019, and these are some serious allegations, why didn't you just go arrest the defendant?
We have procedures within our department, and when you're in the investigative bureau, when a detective submits to the district attorney for a warrant and the warrant gets approved, at that time, the procedures are to send it to our criminal apprehension team to apprehend the suspect if, in fact, the warrant is approved by the district attorney's office. And that procedural technique was often used at that time, and that's the steps that I took for this case.
So, in 2016, you knocked on the defendant's door. Am I correct?
January of 2016, yes.
You knocked on the door. so you knew where the defendant lived.
That's correct.
So my question is, when you get a warrant, this is a big case. This is alleged crime against kids. So would you want to get that person out of the community, off the streets?
Is that a question? Or
Yes, would you want to get that person out of the community, off the streets?
if there's a person sexually abusing children and I have that factual information to make that determination, yes.
So why in 2016 wasn't officers sent there and apprehend Mr. Davis?
There was many investigative steps that I had not completed that I wanted to complete for the case.
So it was your call not to call, send in and have me arrested?
That's correct.
I'm gonna ask to strike now, please.
It'll be stricken, there will not be any comments.
Oh, I'm sorry. So let's get back to your police report. So, in your police report, where did Mr. Davis meet the alleged victim, Vanessa Robinson?
I recall it was at a Fatburger restaurant.
And was she with someone or was she alone?
Vanessa Robinson stated she was alone.
Was the defendant with someone?
She recalled a female juvenile around her age with the defendant.
When did she say she met him on Facebook?
Well, objection, hearsay.
Sustained.
So, did Vanessa tell you about some,
Objection, hearsay.
Is there a hearsay exception that you have?
yes, I got his testimony, I got his volunteer statement is what I'm on, basically.
Right, so I'm asking you if there's an exception to the hearsay rule you'd like me to consider.
Yes, because it's his statements, yeah.
So the objection is sustained.
So, in her statements to you, did she tell you how long she knew the defendant?
Objection, hearsay.
Sustained.
Your Honor, these are not hearsay because she testified to these statements, so it cannot be hearsay. Plus, she will be returning to the stand tomorrow, so it cannot be hearsay. If someone testified to it already.
So it's an out-of-court statement offered for the truth, and I haven't heard a specific exception. Just because she already testified doesn't make it an exception.
It was not an out-of-court statement, it was an in-court statement.
So the document that you're pointing to is an out-of-court statement.
Yes,
So
this
unless
one.
there's an exception to the hearsay rule, those statements cannot come in. So if you believe that there is an exception to the hearsay rule that you'd like me to consider, I'm happy to do so. Thus far, I have not heard an exception, so the objection is sustained.
Did the defendant, did the victim, alleged victim, tell you about any scars on the defendant?
Objection, hearsay.
Sustained.
How old did the defendant tell you she was?
Objection, hearsay, foundation.
I'm sorry, how old did the defendant tell you
Did the
she
victim
was?
tell the detective she was?
That's sustained, that's hearsay, unless you have an exception you'd like the court to consider.
Yeah, the exception is, Your Honor, 51.035, hearsay defines, subsection 2A.
Which is?
It's inconsistencies with the declarations of testimony.
So an inconsistent statement?
Yes.
And so, I apologize, you're stating that,
This is inconsistent with the inconsistency with the declaration of testimony, the clearance testimony.
approach.
So I'm just trying, in order for me to get a prior inconsistent statement, I don't know if you're stating what she said on the stand was inconsistent with what she said in the statement. Where is the inconsistency in your opinion?
It's inconsistency opposed to what she said and what he's saying. So it's in the,
Tell me. She said this, and he said this. Tell me what's the inconsistency so I can.
well, the inconsistency is going to be the age also.
Yeah, I know. Tell me what she said.
Well, in the grand jury indictment, she said I was alone. To the officer, he's saying that I was with someone. That's inconsistent.
Well, I think
I got the grand jury indictment where she says, oh, he was alone, but he's saying that I was with someone. That's totally inconsistent.
Okay, I just want to make sure we're talking about her grand jury testimony and not China's or anybody else's.
Right.
So you're saying that grand jury, she said that you were alone,
Mm-hmm.
but then when she told him, she said that you were with somebody?
Yes.
Okay. Are those inconsistencies there? Because I don't have knowledge of who the grand jury said.
Well, it is, but he's the wrong person to ask that. That's a cause for her. He has no opinion about what was said at the grand jury. Do you know,
At the grand jury, yes.
right, so if he wants to cross-examine, if he wants to ask, can lay a foundation from yesterday's testimony and the statements in her voluntary that he took are inconsistent, then he may have a leg to stand up, but he can't cross-examine him about grand jury testimony.
Your Honor, basically,
That's true. So if she says one thing in her voluntary statement to him, okay, and then she came in here and she testified in here to something different, then you can bring that up to him and impeach her through what she told him. But grand jury can only do through her because he wasn't there. So if you have something that's inconsistent between her voluntary statement and what she told him, then you can get into that. And that
that's
would be
what I was getting into.
No, you just said you were talking about grand jury.
Well, I was talking about her. He got me with saying I had somebody with me. In the grand jury, she's saying
In
I was
the
alone.
grand jury, we cannot get into with him. You can get that into with her. If you have something about inconsistencies between what she told him and what she testified to, that is an exception to the hearsay rule. He can't talk about grand jury because he doesn't know anything about that. You can cross her, okay? So if you'd like to get into the voluntary statement, any inconsistency between what she testified to here on Friday and what's in that statement, that is fair grounds. Grand jury is out. Got it? Okay.
Your officer, your ID process. Tell me how you do your ID process.
Can you ask that in I guess a different question? What kind of ID process?
Yes, how do you go about doing your lineups? Do you bring the suspect in, do you bring the victim in, is it not behind the TV screen, or do you line up people with them, or how do you do it?
So the photo lineups are a set of photos that are, it's an array of photos that are presented to the witness or victim, in this case, a victim and a witness, and in this case, a sequential order, one photo at a time, with a set of instructions that are from our police department.
So you mail them to them?
No, in this case, they were done with the victim. In this case, I utilized a staff member from the Caliente Youth Center to complete the photo lineup for me.
So you had a staff member do your photo lineup, officer?
That's correct.
Why wouldn't you do it yourself?
Miss Vanessa Robinson was away from Las Vegas, and it's often, at times, best practice to have someone that has no knowledge of the investigation or suspect information to complete a photo lineup, so they're neutral in the case. And in this case, I felt it would benefit the case to complete, to take that investigative step and complete the lineup with someone else.
So basically what you're saying is you had staff at Caliente, instead of the police, conduct a photo lineup.
Yes, I did.
So you yourself never did a photo lineup?
Not with Miss Robinson, no.
So when you're having a staff do the police work for you, what kind of instructions do it come with?
It comes with the LVMPD instructions that are downloaded from our police department's Word program, and it's, in this case, printed along with a set of photographs and mailed over to Mr. Tyler Peterson.
So do you think this is secure?
Excuse me?
The method from which you use to identify people, do you think this is secure?
I don't understand the question, Mr. Davis.
Do you think it is secure that you would send over something to a staff, photos to a staff, and tell them, download this, go through these instructions in your letter, and then give it to a alleged victim, and then have them pick out something? Do you think that's fair?
Well, objection, that calls for legal conclusion, fair.
Yeah, I think it's vague, but I also, if you're talking about the reasonableness of
Right.
the photo lineup, I think that is a legal conclusion. So if you'd like to rephrase it, if you think it's best practice or something like that.
Do you think this is good practice for the police department?
It's not common practice for me, but in some cases, I have made that decision to do that.
So why wouldn't you just drive out there and do it yourself?
I chose not to in this case.
Can you tell me why you chose not to in this case?
I had a connection with a staff member, Mr. Peterson, and I made the decision to send the photo lineup over to Mr. Peterson to complete it.
And I'm guessing when you, well, I'd like to ask you, going back to your Facebook warrant, found out the years was wrong, why didn't you fix it?
I was in preparation for this trial, and I decided not to due to the fact that it could take several weeks to a month to do this, and I had enough information to show communication between the defendant and Vanessa Robinson.
But don't you think a defendant or even a victim would deserve that? The right dates?
Objection, argumentative.
Well, Your Honor, I'm just trying to see why.
Okay, then rephrase, because that's the same
Okay,
as
so-
argumentative, so rephrase please.
I'm trying to understand the importance of these dates are very important. Do you agree?
I do, sir.
So, do you agree that they should have been fixed?
I should have had the correct dates in the first place.
So, in the first place, when you find out they're not the correct dates, don't you think you should have corrected it? No matter if it took a couple of weeks, a couple of months, whatever?
Well, in this case, the purpose of the search warrant was to show communication between Vanessa Robinson and the defendant, and to show the link between both subjects. And I believe I had enough with that information that I had received already from Facebook.
Okay. Saying that's your, okay, so basically you got all the records from 2015.
That's correct.
What age in 2000, what age would Vanessa be in 2015?
She could have been, it depends on the year, but she could have been, when I made contact with her, she was 14, and she could have also been 13 in 2015.
I would like to give you her birthday on the report, but refresh your memory.
Okay.
As soon as I can find it.
There's states admitted one with her birth dates on it.
Okay, so let's tell the detective this.
Okay, can someone pass me one, please? Thank you. Is it your request that you have a look at this?
Yes.
All right, so Detective, I'm going to research exhibit 1. If you wouldn't mind just taking a look at that.
Okay.
Do you have a
So,
question?
in 2015 is where your alleged communication between the defendant and the victim happened.
Well, Your Honor, I'm going to object to any correction.
Sure.
So, does he understand he's opening the door to Facebook now? Because he keeps going over and over this 2015 communication, and that directly opens the door to all the Facebook accounts.
I believe you're aware of that, right? You're
Yes.
asking specific questions.
I'm going over what date that he said this, that I'm basically destroying his Facebook evidence, because
Sorry, what?
his Facebook, I'm going over the dates that is totally wrong in the Facebook. So to prove that, her charges of under 14 don't exist. See? So, which is 6 charges of under 14.
Right?
I'm proving that this is impossible.
No, what Ms. Kollins is saying is by the questioning that you're going down the lane and talking about specifically about the Facebook records, is that you're opening the door for him to defend the information that he received in those Facebook
Oh,
records.
he can defend it.
Okay.
He's
Right,
not saying.
she just
He
wanted to
can
make sure
defend
you were
it.
aware of that.
Right.
Weapons are going to be admitted. You understand that, right?
Well,
What?
yeah, go ahead.
Okay. All right, great. So let's go back.
So Officer Martinez, in 2015, how old would she be?
Which she could have been, she could be 14 and she could also be 13. Because her date of birth is January 25th, so before January 25th, she would have been 13 years old. So both ages during that whole year, to answer your question.
So basically, you're saying if you're a year off, like you said you were, your years would be January 25th, 2014, to January 24th, 2016.
Your Honor, I'm going to object. That mischaracterizes the testimony. He said his date was off in the search warrant, no place else, so I don't know.
So I'm going to just ask that you clarify, because we're talking about a lot of dates, so date for Facebook, date
Your
for
Honor,
events.
if his date is off.
Just re-ask the question to him, please.
Okay. So, you have admitted several times that your date was off. So, if your date is off, it would make your year, oh, I can ask you, would it make her a year older?
Objection vague. I'm sorry, I don't understand that.
Sustained, I'm sorry, I'm a little confused. Would you
Okay,
please re-ask?
Your Honor, if somebody's a year off,
Okay, I can't talk to me, you've got to
Okay.
ask him a question.
okay, officer, if somebody's a year off, Detective Martinez, if somebody's a year off, and then you correct that year, would they be a year older?
Your Honor, objection, vague, foundation.
Sustained as to vague. And actually, officer, do you understand, if you understand the question, feel free to answer it.
My clerical error doesn't change her age, if that's what you're asking.
So basically, no matter if it is 2014, which,
She would have been 12 or 13, sir.
do you have a birthday up there again? Can you take a look at that again?
Okay.
Okay. Now, your statements. I'm going to read your statements. How old did you ask her in your voluntary statement she was?
Well, objection, hearsay.
It's his statement.
Are you asking what her answer was to
Yes,
this question?
no,
How old
I'm
are you?
asking him, how old did she tell him she was?
Sustained, that is hearsay.
During your interview with the alleged victim, how old did she tell you she was?
Same objection, Your Honor. And it's foundational too, because how old did she tell him what her birthday was, or regarding the incidents, so.
Can you clarify the question, please?
Your Honor, it's very important that they know.
And sir, I need you
Okay.
to ask him a question.
What day was your interview done, officer?
July 23rd of 2015.
How old was your alleged victim at that time?
She's 14.
So, during your investigation of this, when you went to Fatburger to interview the employees or to get the tape, what did you see?
Sir, I did not go to Fatburger.
You didn't go to Fatburger?
I did not.
So the place that your alleged victim met the defendant, you didn't go.
I did not.
Can I ask why?
I did not have a set date and time, and I did not go over there to just I did not go over there to confirm that they were there or not.
So you did not go to Fatburger to confirm that the alleged victim and defendant was together?
I did not.
And is there a reason not to? Can I understand your reasoning, Detective Martinez?
The interview was almost a year after the fact, and I did not have a specific date and time to locate, in this case, any information that would have showed them that they were there. So I decided not to go over there to look for them.
Okay, officer. You, all these crimes, allegedly, where did all these crimes take place?
At the defendant's residence,
Did you go there and investigate?
I went over January of 2016
So-
in attempts to make contact with the defendant.
So you went into his apartment in January, when?
Did not go into the apartment.
You didn't go in the alleged crime scene place?
I did not.
So, you did not go into the defendant, what day did you go into the defendant's apartment?
I did not go into the defendant's apartment.
So you never been in the defendant's apartment?
Not inside, no.
So did this happen on the outside of the apartment, Detective Martinez?
The incidents were alleged to have happened inside the apartment.
So why wouldn't you go inside?
I made the decision not to go inside the apartment.
So, let me get this straight. You made the decision not to go to Fatburger, and you made the decision not to go into the apartment. Am I correct?
That's correct.
Is that common for the police department not to go to a crime scene or alleged crime scene?
In some cases, we don't go to the crime scene, or we don't have the availability to get into the residences due to the time between the allegation is made and the time that the incident occurs. In some cases, we don't have enough probable cause just to go in someone's apartment or residence based just on an allegation. And during my contact in January of 2016, I made that decision not to go in to the apartment, but to just attempt to talk to the defendant over the phone and cordially schedule an interview with him.
So, basically, what you're saying is you're trying to get a confession without doing any investigation.
Objection, argumentative.
Sustained.
So, did you want the defendant to confess on the phone?
Objection, argumentative.
Let's,
Okay,
can
so-
you rephrase it, please?
Did you ever call the defendant?
I did not.
So, you didn't call the defendant ever?
I did not.
So, you never went to Fatburger, you never went into the house, and you never called the defendant. Am I correct?
That's correct.
And you got the Facebook page wrong. Search mark wrong. Am I correct?
That's correct.
How did you go about receiving the defendant's phone number?
I believe the defendant had called me that same day I made contact, so I believe that's how I obtained the phone number. Or one of the ways I obtained the phone number, but I'm not sure.
Let me refresh your memory. Can you read this?
What is that?
We're helping refresh your
Right,
memory.
what are you asking?
It's the voluntary statement where he says how he obtained the phone number.
Well, objection to the narrative and it needs to
Would
be.
it help if you read some of this so you can refresh your memory of how you got the number?
Yes.
Thank you, Officer Pepper.
Can you give him a page number, please?
Do you have a page number for the detective?
Page 7.
Is there a specific page you want me to look at?
18.
Okay.
Does that refresh your memory how you got the number?
No, it does not.
That doesn't, so you have no idea how you got the defendant's number?
I don't recall, sir, how I obtained that phone number through my investigative steps,
Can you
because the
read-
defendant called me that day I left my business card.
Can you read page 18?
I did, I reviewed it, sir.
So can you read it for me, please, so I can understand more myself?
Well, objection calls for hearsay and argument.
So you can't read it because it's hearsay unless you have an exception to the hearsay rule you'd like to apply.
Yes, Your Honor, it's not hearsay if it's his statement
That's,
in the police report. If it's his statement asking a question, obviously, if he says it's his statement, that's him asking the questions. So he should be able to read that, what he said.
okay, so he's looked at that, that doesn't refresh his recollection. So if there's another method you'd like to use, that's fine.
Okay. So, you're saying when the defendant called you, that's when you obtained his number?
It's possible. I don't know for sure.
There has to be, you have to have, I mean, Do you have any idea how you obtained the defendant's phone number?
Well, in my experience, you could obtain it many ways. You could obtain it with the victim providing it, the witness providing it, a suspect providing it, person of interest providing it, police records, old police records, social media information. There's a lot of ways we obtain specific phone numbers, but I don't recall in this case how I obtained your specific phone number, sir.
So even after reading page 18, you didn't understand?
Approach, Judge. Approach.
So here's the thing. He has been on the stand for over 2 hours, right? This jury is getting increasingly agitated by you continuing to ask the same question over and over and over. If a person, if you ask a question and that person answers it, you may not keep re-asking it. You are stuck with the answer. If you believe there is a way to get that, there's whatever you're trying to gain, if you believe there's a way to get that in, then you need to go ahead and do that. Otherwise, this has been asked and answered literally at least 9 times, and we need to move on.
So, Detective Martinez, you have the defendant's address, you have the phone number, you have the address, am I correct?
That's correct.
You have the defendant's phone number, am I correct?
That's correct.
Why did you attempt to make contact only one time?
That conversation with the defendant, as I recall, said he did not have any knowledge of who Vanessa Robinson was and did not want to talk about the matter. So I made that decision not to proceed to make contact with the defendant because of his response.
So when the defendant was taken into custody, I'm sure you went and interviewed him. What was said?
I did not interview the defendant when the defendant was taken into custody.
You never interviewed the defendant?
I did not.
Can I ask why?
Oh, Your Honor, may we approach? He wasn't on the arrest team, as I'm sure the court remembers, and I don't know if he has read his rights and invoked his right to an attorney, so he's getting dangerously close to that information. This detective wasn't there. So I just want to make sure we don't have some invocation of a right to counsel on the record that...
I wasn't read my Miranda rights.
Did you ask to speak to an attorney then?
Hmm?
Did you ask to speak to an attorney?
No, I didn't.
Okay. So, what Ms. Kollins is doing is she's trying to ask to protect your constitutional rights. If you have a right to remain silent, you have a right to an attorney, and so if you invoke those things and comment on it and invoke those would be a problem. So she's just trying to make sure those interests are protected.
I was never read my Miranda rights. I was never formally arrested. So I was never given any rights. So when he called, when I was in jail...
Because it just said, did you ever attempt to contact me or interview me? And like you said, he said no, and you can say why, and then move on.
Okay. Thanks, Your Honor.
So, at any point did you attempt to contact me?
So yes, I did.
At what point did you attempt to contact me?
On 2 occasions, once in person at the residence and over the phone. when you contacted me.
So me contacting you is attempt for you contacting me?
That's considered contact, yes, sir. And I attempted to schedule that interview to sit down and talk about the investigation, and you did not want to talk about the matter. So that was the extent of the contact I had with you.
So, getting back to the Facebook and your Facebook warrant. Is from, what month is your Facebook warrant from?
January 1st of 2015, I believe.
To when?
I believe it was, present time would have been on April of 2015, I believe. Without looking at that actual warrant, that's just an estimation on my end.
Can I refresh your memory?
Yes. Okay.
Now can you tell me what's wrong?
The warrant has a clerical error as well. It reads January 1st of 2015 to April 2016.
Can you explain what a clerical mistake is?
It's just something that was typed in the report or a document that I did not intend to put in, but after proofreading didn't catch it, or the other person proofread and catch the error as well.
Another person proofread it, officer?
That's correct.
So, you made a mistake with this date, and another person who proofread it also made a mistake.
Of proofreading, yes, sir.
So, this one, what did the warrant supposed to be? What the date supposed to be?
It's supposed to be to April 2016.
So the three names you have: Raymond Davis, 3388630, Poker Star Raymond Davis. Did you get a warrant and search the Facebook profile of Poker Star Raymond Davis?
Yes, I did.
Can you tell me what you found?
Nothing was, I don't believe anything was taken out of that user profile to nothing pertained to the investigation. I believe, without looking at the records, with any, and that would include any communication with Vanessa Robinson or Raymond Davis, but there was a warrant that was served on that user profile.
So, the second profile, Poker Star Raymond Davis, you found no communication between the alleged victim and the defendant.
Without looking at those records, I don't believe so, sir.
So everything you found was in Raymond Davis, 3388630.
That's correct.
While you looked through them, 2,000 pages, you said? Was it 2,000 pages?
The 3 usernames, it's over 2,000 pages. I don't know exactly how many pages total.
Somehow, the state did not give me 2,000 pages.
Is there a question, sir?
So you looked over 2,000 pages of Facebook records, right?
Yes,
Did you give those 2,000 pages to the DA?
I pulled the pages pertaining to this investigation to the district attorney's office.
So basically you weaved through 2,000 pages and said,
Objection, argument.
Rephrase the question.
so how did you do this? How did you go about deciding which pages to give the DA and which pages not to give the DA?
There's a lot of confidentiality between messages with people online, in this case with Facebook. There's a lot of messaging with the defendant and other individuals, females, males, and I only pulled the information that linked both Vanessa Robinson, Adriana Walker, and the defendant. There was too much information with and contact with other individuals that I felt was not necessary to include in this investigation. That was my decision.
Officer Martinez, did you delete some items off of Facebook?
I did not.
Officer Martinez, on the profile Raymond Davis, 3388630, was there any other individual using that Facebook profile that contacted the alleged victim?
I would not object as vague. I don't,
Can you state the question again, please?
Basically, what I'm saying, officer, is did any other individuals contact the alleged victim, Vanessa Robinson, through the Raymond Davis Facebook page? Or was it just Raymond Davis contact?
I don't know, sir. I can't show that someone did.
I'd like to try to refresh your memory by
So, Mr. Davis, just so I can understand the question, you're asking him if someone was using the Raymond Davis Facebook account to contact the victim that was not you, and
Right.
is that correct?
yes, Your Honor.
All right, and your answer was what, so that you wouldn't be able to state that, to tell?
I can't prove that, Your Honor.
Okay, I'm sorry, what was the next thing?
I'd like to refresh his memory.
With, what?
I got page 7093, I won't make any exhibits, and 70.
Those are the Facebook records?
Yes, 7092 and 7093.
So you're asking to admit the Facebook records into evidence?
I'm asking him to refresh his memory by reading this.
Okay, so you're asking to refresh his recollection?
Yes.
All right. Would you, Marshal Kelly, would you please show Ms. Collins, you have a copy, correct?
I do.
Oh, could you please show the detective?
remember reading that page?
I did read that page.
So, what's the individual that's messaging her from that page thing?
The author is Raymond Davis.
Yes, and who's messaging her from that?
Sir, the author is Raymond Davis.
I understand who the author is, but if you see the message to message, you see different names in the message to message?
I do, sir.
So, is it another individual in the inbox?
In the first message that you're referring to, it says, "This is Kelly."
Kelly.
Yes, sir.
Can you read for the court what it says?
The message that I'm seeing, it says, recipient Vanessa Robinson, author Raymond Davis, sent on March 25th, 2015. This is Kelly. I'll tell Ray you hit him up. You have a number you want me to give him? Question mark, question mark, question mark.
Okay, now read the rest of it.
Your Honor, the state's gonna at least ask that you admit this conversation now that we've started to read some of it out of context. I believe that's marked as states 5 up there. I have no objection to his admission, but I do object to reading it out of context.
So we're not just gonna read pieces of the document, so do you have any objection to the entire document coming in as evidence?
Then no, I have an objection to that. I want that to come in.
Obviously, you didn't just get a piece.
Well, Your Honor, well, I don't want to question you. If you look through 2,000 pages of Facebook records, and you see other people in this alleged Raymond Davis inbox, would that create doubt in your mind? Any doubt in your mind?
Objection, vague, legal conclusion.
So you're asking him if he reviewed the documents, so are you saying, is this a hypothetical or this is, did you review
Hypothetical.
those documents? Okay, so hypothetical is sustained as speculation. If you have a specific question about what he did in this case, then I'm happy to go forward with a different question.
So again, Officer Martinez, are you a numbers person?
I'm sorry, are you a what?
Numbers person.
Are you a numbers person? Are you good with numbers?
Sir, I'm a detective with the police department.
Are you good with numbers?
I don't know how to answer that, sir.
Can you count?
Yes, I can.
So, I'm trying to pose this in a question that don't get me objected. Officer Martinez, what's the email linked to that profile, Facebook profile? What's the email?
To which profile, sir?
The one you did work on, Raymond Davis. Not the Poker Star one, but Raymond Davis.
I don't know if I attached an email to the evidence I presented, but I believe It may have came with the downloaded information.
Did you know, Officer Martinez, that every Facebook profile comes with an email?
Yes, sir.
So tell me the email of this profile.
I don't have the records in front of me, sir.
Where are they at?
They're still in the portal.
Can we go into the portal and get them?
I could, yes, sir.
So why wouldn't you bring them so we can know the email it goes to?
I did not bring that information with me, sir.
So basically saying you got a Facebook profile that you are claiming to be a defendant, but you have no email to it. Is that what you're saying, officer?
There's no email attached to these documents here, but there was, if I recall correctly, there's emails and phone numbers and names attached to Facebook user profiles.
So again, I asked you, why do you bring them?
These are the pieces of the Facebook documentation that I included with the investigation. It's not to say that I don't have that information.
Can you obtain that information?
It's every, the information is within the Facebook portal, sir.
So I'm looking at this and it says user identification number, email address, date, timestamp, account creation date, most recent logins. Do you have, Officer Martinez, do you have the most recent login from this Facebook profile?
Without the records in front of me, sir, I don't know what the
Is
recent.
there any way we can go on recess and you can go get the records, Officer Martinez?
I can't call recess, sir.
No, okay. If we went on recess, hypothetically speaking, we go get the records. The email.
I can provide the records that Facebook provided me, yes.
So, why do you provide this? I mean, do you think that's relevant, Officer Martinez, to identify a person by having the email and the Facebook?
I made the identification, sir, with the profiles provided and made the identification to the subjects involved.
I thought you said Claudiento, the juvenile facility, made the identification. I thought that's what was said. I thought you said you mailed it off and they did the identification process for you. That means you didn't do the identification process. Somebody else did it.
Well, I had you identified prior to the photo lineup, and based on my experience and the information I had gathered, I had a good possible lead that it was you. And that information
What
was,
your
Let him
possible
finish,
lead?
please. Go ahead and finish, and then you can ask your next question.
Okay.
that information is then, in this case, sent to the victim so she can make the identification as well, which was.
Now you want to tell us your lead?
I'm sorry, sir?
Do you want to tell us your lead, the good lead that you had?
The lead was the name provided in this case. I believe was the first prefix of the phone number, 562. The lead was also the general area of what the victim described, Vegas Valley and South Nellis Boulevard, and the apartment complexes within that area.
So your lead was a phone number, 3 numbers of a phone number, right? Is that what you're telling me?
That's correct. That's one of the investigative leads I had.
So you didn't think of just match the Facebook with the email. You didn't consider that.
I don't understand the question.
When you got all the information from Facebook and everyone, you didn't say, okay, I have all this, let me try to match the email to this case. Or IP address.
No, because I believe that Facebook address or the user profile was the defendant's.
Because you believed it,
That's correct.
but you didn't have no evidence that it was the defendant's.
Just the evidence that I had provided Facebook and the evidence that they in turn provided me.
You're 562. Your lead.
I'm sorry, sir?
You're 562, your lead. Your secret lead, your lead that you got was the 562.
Yeah, that prefix, I believe, is somewhere on the Facebook records, so I was able to match,
So-
at least match the name.
So instead of matching an email and an IP address, you just matched 3 digits of a phone number.
That's not all I matched, sir.
I would like, can you explain?
I matched the name of the person, and I also matched the user profile picture to the description given by Vanessa Robinson.
But you also matched that and did all of that to the Poker Star Raymond Davis account. Am I correct?
That's correct.
Go ahead and move the approach.
Yeah.
So my assumption is if he keeps pushing on this, I mean, he has prior arrests. 1998, Hayward, California, lewdness with a minor, the 2004 case here. If he keeps pushing this, I'm sure that went into the investigation, and I just don't want that door to be opened. And I hadn't really talked to the detective about that because I didn't think we would be on this for this length of time.
Sure. Just wanted to be really careful because you're opening the door. Another thing.
The jury's getting tired.
Right, that's what I've been trying
So
to
we
tell
gotta
you for the
stop
last
having her
time.
object.
No, Mr. Davis, if you've gone into something, we're moving on. So I have told you multiple times, from now on, if you ask something that has already been asked, I will admonish you to move on. This jury has been hearing from this.
Right.
It's not about her objection.
I agree,
It's about
Donna.
your inability to move on. Pick your questions. They have to be within her direct examination, and then we're moving on.
Okay.
We can't be doing this. We are in the second week of trial. We are on the second witness. I've never seen anything like this, ever. Ever. They are getting
Because she's
increasingly-
slowing us down, Your Honor.
Excuse me?
She's slowing us down.
Sir,
She
you need
keeps
to-
walking us to this bench.
You chose to represent yourself, and that is within your rights, and everybody respects that. But on recess, you may want to speak to Mr. Klaus about some of the
We
strategic
can go to
decisions.
recess.
We're not
I
going
agree.
to just right now. You go
We're
ahead
not
and
going
go.
to, my feet are killing me. The
Oh,
jury, look at
you
the
have a
jury.
choice. Keep going.
So, this mistake on the date, when the guy also proofread it and gave the date, why didn't you fix this one?
Facebook had recognized, because we had sent a preservation later of the exact dates, they had recognized what the dates I wanted, and so they had sent me the information that I requested.
They haven't sent it, is that what you said?
But they had sent it with the information provided.
So with the wrong dates, 2 different times,
Objection mischaracterizes the testimony.
Sustained.
with the mistake here, how much time did you have to fix this mistake?
I had enough time to fix it.
You had enough time? So why didn't you fix it?
Okay, we have gone over this subject multiple times. It has been asked and answered. Move on.
Your Honor, that was
Asked
the first
and
one.
answered. Move on.
Martinez, do you make a lot of mistakes?
Objection, argumentative.
Sustained.
So, during your interview with the alleged victim, Vanessa Robson, you did a laundry list on what she alleged happened to her. Do you recall?
Yes.
Can you tell the court what was the things that she said was done to her?
So, in my interview with Vanessa Robinson, she alleged she had went over to Mr. Davis's apartment and specifically recalled the living room area, and she recalled something to the effect of, you do a favor for me, I'll do a favor for you. And Mr. Davis initiated the contact by placing her hand onto his, she said, private area.
Officer Martinez, that's not the
Excuse me.
laundry list.
That's,
No?
no, excuse me, you need to let him finish his answer, and then you may ask your next question. Please don't interrupt witness. Detective Martinez, proceed.
So Mr. Davis, she stated Mr. Davis had grabbed her hand and placed it on his penis over the clothing, and said that he didn't want sex, but asked for oral sex. And Ms. Robinson recalls giving him oral sex for about 5 minutes, and then stopped. And then she recalls a time when she stated she was with Adriana Walker inside his apartment, and this stated that Mr. Davis instructed them to get into robes, and they had been drinking alcohol, and she believed, Vanessa Robinson believed, that he had slipped something into Adriana's drink, and he offered both of them to shower.
Object. Object to hearsay. Approach.
You mean you'd like to
May I
approach?
approach you?
Yeah.
You know what, we're gonna take a recess.
During the recess, you're advised not to talk or converse among yourselves or with anyone else on any subject connected to this trial, or read, watch, or listen to any report or commentary on the trial of any person connected to this trial by any need of information, including without limitation to newspapers, television, the internet, and radio, or form or express any opinion on any subject connected with the trial until the case is finally submitted to you. If you would please be out front in 10 minutes, thank you.
All right, so the action here.
All right, we're outside the presence of the jury. Detective Martinez was just answering a question. You can have a seat, sir. So Detective Martinez was just answering a question that was asked by the defendant. The defendant's question was, what was the laundry list of things that the victim told you occurred? Your objection is what, sir?
He's talking about something that isn't even in the police report, slipping something in somebody's drink.
Was that in her voluntary statement?
No, no, it's nowhere. It's nowhere in here. He's just bringing it up. Stuff that's not even in the statement.
Was your am I correct in your question was what was the laundry list of things the victim told you that occurred?
Yes, the alleged victim.
Yes.
What was the laundry list of the things the alleged victim told you? Not something you're making up and putting in.
Thank you, Detective Martinez. Can you explain for the court the questioning, when you spoke with Vanessa, was that done purely on tape? Explain to me how that was done.
That piece of information, Your Honor, is in her statement, because she recalls the incident between her and Adriano Walker at his residence where he attempts to have them shower. So that information should be in the transcription, and it's not verbatim, but that's what I'm recalling from the interview with her.
About the, which part did you object on? There was alcohol and...
He's talking about it was alcohol, there was something put in somebody's drink.
Oh, that she believes something had been taken from her drink?
I mean, where do you get that from? I done read this 100 times.
Hold on.
Yeah, I mean,
I remember the alcohol, Your Honor, I'm just trying to bring it for you just a minute. I mean, he did ask the question, what was the laundry list? I don't know. Every time he gets an answer, he doesn't.
So, yeah, I mean, you opened the door to the laundry list. Now, if the fact that if she didn't say that she thought somebody slipped something into her drink, then I agree, and I'll advise the jury that they can't consider that.
I think we should have a mistrial. That comes in the evidence that he already polluted the jury with this statement that's nowhere in here. It's hard just to tell a jury to forget what they just heard when an officer just talks about pills and stuff, drinks and stuff being put in somebody's drink.
I don't see that in Vanessa's statement. I'm gonna look at Adrian's really quick, if the court can give me a moment.
It might be in her statement.
Do you remember seeing it in her statement?
It was a reference to, I put something in her drink,
Okay.
Adrian statement, but it was not in Vanessa's, and that's what we're on. So he just jumped a witness that's not even testified, jumped over to her when we're clearly on Vanessa. I asked this court call this mistrial. He has polluted the jury with that. One guy on his way out gave me an evil face, like he didn't hear this before.
Can I look at my statement, Your Honor?
Your statement?
Or the statement with Vanessa Robinson?
Yes.
Here, I'll give you a copy. You can have mine.
Marshall O'Kelly, could you please approach the witness with the copy of the...
Thank you, Your Honor. Thank you.
I have
Thank
it.
you, officer. Okay.
There you go.
Clean house. This is not small, Your Honor. This is humongous.
Well, Adrian's gonna be here, so.
Well, she's not here yet. She ain't testified. Well, it's easier to say.
Okay, I found it, Your Honor.
Page what?
It's page 17, last paragraph.
Can you read it, please?
So no, but one time my friend went over there with me, and we were drinking alcohol, and he put something in her drink, and I knew about it. And before that, he made us change into robes.
I wasn't testified to.
Page 17.
Yeah, I'm looking at it.
You asked him for a laundry list of the things that she gave.
That she said was done to her. That's what I said. Laundry list of things that was done to her. That's not something that was done to her. She's talking about her friend. And he put something in her drink. And he put something in her drink would not be referring to Vanessa Robinson. Putting something in her drink is referring to Adrian Walker. I asked that this court call this is a mistrial.
Because he answered the question that you specifically
No,
asked.
Your Honor, when I asked him to go down a laundry list of things that was done to Vanessa Robinson in his statement. It's clear that Adriana Walker and Vanessa Robinson is two different people. So he's putting things in Adrian Walker's that hasn't testified, putting things in her testimony. I could see if she had been on the stand, Adrian Walker had been on the stand already, and then he wants to bring that in, testify against that. But when we're on Vanessa Robinson and the laundry list of things that she said I did to her, this is not things he said that I did to her. This is things that he's pointing out is done to Vanessa Robinson. I mean, Adrian Walker.
He asked the question, and I understand he doesn't like the response, but in describing what happened to her, she's describing the circumstance of that whole day and that whole encounter. So that is describing what happened to her. She was asked to put a robe on, her friend was with her, there was alcohol, she thought there was something in her friend's drink. That is describing her personal experience, and he asked the question. You know what, Mr. Davis, I interrupted you once.
I didn't interrupt.
I know, but your comments and your constant giggling and laughing, I've told you, if this behavior continues, I will appoint an attorney for you. Because you are allowed to represent yourself if you can conduct yourself the way an attorney would conduct yourself. If you can't, then you sit down and you get an attorney. That's your second warning. Well, really, I mean, honestly, it's like your 20th, but that's your second formal admonishment where I've had to tell you, I will appoint an attorney. Go ahead, Ms. Collins.
He opened the door, he asked the detective what Vanessa told him happened to her. Just because somebody else was there and something happened to both of them doesn't mean it was non-responsive. So, I mean, he opened the door.
All right, so I do find that you asked the question, did she provide you a laundry list of things? What were those things? I do agree that she was saying that she thought that the defendant put something in Adriana's, or Adrian, whatever her specific name is, drink while the two of them were there and that he had provided them alcohol. I don't believe that that raises to the level of a mistrial. If you'd like me to give the jury a limiting instruction, I'm happy to do that. But you have asked for a laundry list, the laundry list of things that this victim told him happened. And so that's what he's answering right now. If you would like me to do a limited instruction in regards there to disregard the statement that he had provided, she believed you had put something in her drink, I'm happy to do that.
Your Honor, this is an uncharged bad act.
That's
This
why
is-
you don't ask open-ended questions like that.
This is an uncharged bad act that he just put in. He just tainted the jury.
Time out. You read this statement, correct? Yes or no? Have you
Yes.
read you know everything that she said that you did in there, right?
No, I didn't. I misread. She didn't see that. I didn't see that
Okay,
either.
but did you know
I
in
just
there?
read it.
Did you know in there that she had said that you had provided them alcohol or that you were
No, I
having
didn't know.
alcohol? You didn't know any of that was in
No,
there,
I
even though
didn't.
you have line-cited every single page of that document. I can see the highlights, I can see everything.
It's not highlighted, Your Honor.
Your
want to see it?
statement isn't highlighted.
No, you want to see? I'll show it to you. Where's my page? It's not highlighted. I would have highlighted something like that. Here it goes. Your
So,
Honor.
Are you withdrawing the question then?
No, I'm not. Your Honor, the question was,
Sir, I just need you to follow my directions and answer my questions. Are you withdrawing the question?
no, Your Honor.
Okay, so you'd like him to continue to answer that question?
Yes, Your Honor.
Okay. That's where we're at then.
So, Your Honor, I'm saying that the question I asked was pertaining to Vanessa. I told him
And
to say Vanessa
I understand
Robinson.
that. And now he will respond to Vanessa. I understand everything that you're saying. Your motion for a mistrial is denied. If you would like a limiting instruction telling them to disregard that statement, I am happy to provide that.
Okay. I'll take a limited instruction. You can tell me.
Okay. I'd like to take this time to remind you, sir, that I understand that you are representing yourself. This trial, we are in the second week of trial and we are literally in 1.5 witnesses. We told this jury we would be done by Wednesday. They are getting increasingly agitated. You may ask a question once, and once it is answered, you will move on. This is the last time I'm going to admonish you outside of the jury. If it continues to go on, I'm just going to politely remind you, this has been asked and answered, and it's time to move on. Do you understand?
Yes, Your Honor.
Also, I imagine that at some point, Ms. Kollins may have redirect. Whatever she gets into on redirect, you may then go into recross, but we will not be hitting up new areas.
Right.
So obviously, Ms. Kollins, it's the same admonishment for you. Whatever he hit on cross, you may go into on redirect. If you have anything on redirect, but I would just want to remind, whether it's redirect or recross, we're staying within the confines of what the previous person just asked. Is there any questions about that process?
No, Your Honor, but could I, for the laundry list, could you just tell what was done to Vanessa? Or she's told him, not going into the story, his story, but if you just tell, oh, he touched me, oh, he gave her a blowjob, oh, he rubbed her thigh. If he could just tell those.
You don't get to tell a witness how to answer questions. You asked for a laundry list, and now he's giving you the laundry list.
Well, he's adding his own little twist to it, because he's not giving up laundry list for Vanessa, he's giving it for Adriana. Huh?
Okay, so my staff needs a break, so we're gonna take a break now, and then we're gonna get this jury back in here. How much longer do you have with this witness?
2 more hours.
Okay. Just so you know, if it's been asked already, you will be asked to move on.
2 more hours.
We'll see about that.
If I might, I'm trying to organize my schedule for the remaining week. Free them on Thursday for an attempted murder client. I presume that this court will want to be starting as soon as possible.
Yes.
So I'll be,
Would you like me to write an email to a justice of the peace?
I don't think it's gotten to that point just yet, Your Honor. I think the parties might themselves agree to it, but yes, I might need your help with that.
Also, I've had a judge reach out to me and ask if they would like to handle my civil cases for tomorrow so we can start in the morning. I let them know that I didn't know Mr. Klaus's or Ms. Kollins' schedules, and so I don't know if it would be a situation where the parties could be here.
It's kind of witness dependent. I mean, unfortunately, I had 4 people for today. I have 1 left. Their schedules for testifying, I don't know right now. I mean, I had 4 people here for today, and I sent 2 home, and then I kept 1 hoping to get her on. She's not now available till the day after tomorrow, so I have to bring the 2 back that I sent home, and I don't know that I can get them here.
So if we're to take the defendant at his word, he has 2 hours left of cross for the witness that's on the stand right now, and it's 4:15. So that would mean that if we were to start tomorrow
Well, we have,
at 9:30 with this detective, after he was done, we could go into Vanessa at 1.
That's fine with me.
Well, I have to, because these attorneys actually have other court appearances in the morning, so I have to,
could we just do 10, just so I can try to juggle a couple things?
Mr. Klaus?
I'll make whatever accommodation. I've already moved off tomorrow's hearings, Your Honor. It's just a matter of whether or not I get new dates or I have to reach out to someone else to do it. So if you want to start at 10, I'll try and make that happen, Your Honor, and I'll be here.
Okay, thank you. All right, so my staff needs a break, so we're gonna go off.
Your Honor, I'm gonna go release my witness, okay?
342-946-1. All parties are present as counsel. The detective is still on the stand. I remind you that you're still under oath, sir. And it was represented to me by Mr. Davis that he would like the limited instruction that the court offered earlier. Is that still your position, Mr. Davis?
Yes, Your Honor.
All right, bring the jury in, please.
All rise for the entrance of the jury. Ladies and gentlemen, you are instructed not to take into consideration the previous testimony by the detective regarding the statement that it was Vanessa's belief that something had been slipped into her drink. You are to disregard that statement in its entirety, please. All right. So, Mr. Davis, did you wish the detective was in the middle of his testimony. Did you wish him to proceed?
Yes, Your Honor.
Okay, go ahead.
So with my interview, or during my interview with Vanessa Robinson, I believe I left off where she described being in the apartment with her friend Adriana, and Mr. Davis had instructed them to get into robes and offered, instructed them to get into robes. Adriana felt uncomfortable and was wanting to leave the residence. And Ms. Robinson stated that Mr. Davis was insistent that she stay there, and both left. Ms. Robinson stated another incident, she had went over to Mr. Davis's apartment, and he had asked for oral sex, and she stated this time she gave him oral sex for about 10 minutes, and stated that she stopped, he continued to masturbate and ejaculated onto a napkin. Ms. Robinson stated that happened inside the apartment in the same living room of Mr. Davis's residence. Vanessa Robinson stated that she recalled another incident with another female juvenile identified as, or she called her China, and she stated that Mr. Davis offered them both $100 to shower together, and both did in the presence of Mr. Davis, and he sat there, watched him, masturbated and ejaculated onto a napkin as they were in the shower. Miss Robinson stated that the last incident between them would have been, for those incidents, she stated that was probably around the fall or summer of 2014, and stated the last incident would have been a few days or a couple days prior to her being booked at Clark County Juvenile Hall. She stated she was booked in June 17, and stated a few days prior to that she had the last incident with Mr. Davis. And she stated she had gone over there and they were talking about, or she was talking about a lip piercing or something. And she advised him she couldn't really stay because she had an ankle bracelet at the time. And she stated Mr. Davis insisted and wanted oral sex, so she gave him oral sex for about 5 minutes. Vanessa Robinson stated that she had given him oral sex approximately 10 times, and stated that she also masturbated him on, she believes, about 3 occasions, which that information wasn't detailed in her interview. Vanessa Robinson stated that they would communicate over Facebook, and he would ask her to come over and clean, and she knew that was her moment to come over to come see him. And that's my recollection of the statement given to me by Vanessa Robinson.
So, Vanessa Robinson never told you she was touched, her breast was touched?
No, sir.
She never told you her vagina was touched?
No, sir.
Is Vanessa Robinson, would you say, is she a teenage prostitute?
Objection.
Sustained.
When you, officer, when you have an alleged victim like this, do you bother to look into their background?
I do look into everybody's background.
So you look into Vanessa Robinson's background.
It's very difficult to look into a background for a juvenile. It's not information that's just in our database.
So you're telling me you can't get, as a police officer, you can't get juvenile records when you've got a juvenile, you can't get her records?
In this case you're talking about?
Not this case, any case.
I can get juvenile records. I can get records for any subject involved.
Yes, I understand that. So why didn't you get Vanessa's records, juvenile records, and take a look at them?
Like I said, sir, I believe I looked at her, some of the database we have, but her history has no relevance to the alleged crime. I have to be neutral with dealing with any subjects,
So
regardless of history.
you give the same merit, basically, to a person that's been in trouble to a person that hasn't been in trouble. It's the same to you.
It's just documentation that I'm looking at, sir.
So it doesn't matter if they're burglar, assault, gang affiliation, that don't bother you.
That's correct.
So the ability for a person to lie or deceive does not come into your judgment.
Objection, argumentative.
I don't understand the question.
So a person's background and ability to lie or steal, or say somebody's, hypothetically speaking, somebody got a bunch of robberies, somebody got a bunch of assaults, somebody got a bunch of thefts.
I'm going to object to the compound hypothetical.
Sustained.
You give the same merit to a kid that's going to school, doing his homework, or you give this different merit, or you just say one is a straight A student and one's a dropout, that gets in trouble. Which one would you believe?
Not a matter of believing in my position, sir. It's a matter of just collecting the information provided to me, and for me to take the investigative steps to corroborate or not corroborate what's given to me.
So you would go to a crime scene, investigate. You wouldn't investigate on hearsay.
Objection, compound, is that a statement?
Well,
Sustained as to compound.
so, would you prosecute somebody on, would you charge someone with just hearsay evidence, or would you like physical evidence?
Objection, it's not within his purview to speculate on what may or may not be charged by the district attorney.
I'm not talking about the district attorney, I'm talking about you filing a plea.
So you're asking him whether,
Yeah.
in regards to the charges he submits to the district
Right.
attorney's office? Okay,
Mhm.
go ahead.
So, would you charge a person with just saying, opposed to having evidence yourself?
To answer your question, with these type of investigations, when I say these, I'm talking about sexual assaults, sometimes we do have physical evidence, sometimes, say most of the time we don't. So every case is different. So I have investigated cases where I don't have physical evidence, but I do have statements from victims, witnesses, and the person accused of this. And sometimes I do, but every case varies.
Would you ever consider giving your alleged victim a lie detector test?
We don't give victims, specifically juveniles, lie detector tests.
Or wouldn't you want to know the truth?
It's policy and procedures for our police department, sir.
Do you interview most of your juvenile defendants while they're in custody?
Defendants, sir?
Your juvenile victims when they're in custody?
I have, yes.
So you go find somebody that's in custody and you try to get them to confess to something? Is that what you're saying?
Sir, I don't find anyone. In this case specifically, we were called by personnel from the Clark County Juvenile Hall to respond to a sexual abuse allegations.
Do you say, hypothetically speaking, if somebody confessed to prostitution to you, basically teenage prostitution, would you charge that person?
Objection, speculation, and hypothetical.
Sustained in regards to relevance as well as speculation.
I'm trying to find out why. If somebody said they
I
committed...
understand what you're doing, the objection was sustained, move on.
Do you, Officer Martinez, pick and choose who you decide to charge with a crime?
I'm sorry, pick and
Is it your
choose.
choice of who you want to get your police report on and send it to the DA? You choose that. You make that decision, right?
That's correct.
And you make that decision based on evidence. Am I correct?
That's correct.
So basically your evidence was you had a lead with a 562 number. Am I correct?
It was one of many leads, sir.
You said that was your lead.
This has been addressed, asked and answered, move on please.
Did you get the defendant DNA?
I did not, sir.
You didn't ask the jail to get the DNA?
Not for this case, I did not request the defendant's DNA, sir.
So who requested my DNA if it wasn't you? Did you know, or?
Based on my experience and knowledge, if any person commits a felony crime and is processed at our jails, a DNA is taken for those purposes of their procedures, not to do with my case. In this specific case, I did not request DNA from Mr. Davis.
Why not?
In sexual assault investigations, the time frame that we normally obtain DNA from a victim would be anywhere from 3 to 5 days. The allegation was said to have occurred well over a month for the last incident she described. It's not common practice for us to just obtain people's DNA in every case just because. We'd have to have a reason as to why a DNA would be collected, and if so, it would have to be compared to any medical examinations or clothing that, in this case, the victim may have worn.
Officer Martinez, I'm going to kind of end this on this question. What actually did you do in this investigation? Did you do any work?
There was multiple interviews done for this investigation. A search warrant was obtained. 2 photo lineups were completed. An attempt to interview the defendant was made. And again, I think that's most of the investigative steps that I take.
Getting back to your 2 search warrants, your 2 search warrants were written search warrants to Facebook, am I correct?
There's only one search warrant to Facebook, sir.
What was your other search warrant?
I believe I just said one search
No, you
warrant.
said 2 search warrants.
If I did say that in the previous statement, I stand correct. It's only one search warrant, as I said previously, for all 3 usernames.
Okay, so.
I believe I said 2 photo lineups, sir.
2 photos. And you did that, or I thought they did it at Caliente. I thought they did it for you.
One was completed at Caliente with my instructions, and the other one was completed by myself.
That don't seem like too much work. Okay. That's,
Is there a question, sir?
yeah, for a case of this magnitude, do you consider that a lot of work?
I can't answer that, sir, because every case varies, and I can't say it's a lot of work or it's a little work.
So, I'm going to wrap this up. I thank you for your patience. So basically, you came back with a search warrant that was on Facebook, that was, dates were off, and you had a staff that's not trained to do lineups do a photo lineup for you.
Objection, are we going to
That's it. No more for the witness. Thank you, Officer Martinez.
Ms. Collins, you're up.
Detective, in your job, have you collected surveillance videos from locations before?
I have.
You collected them from fast food restaurants before?
I have.
In your experience, what is the approximate longevity of the period of time they keep their surveillance videos?
Usually 30 days. Every establishment is different, but usually it's 30 days to sometimes a couple of months, 60 to 90 days.
Did you have any exact date and time to go look at Fatburger's video surveillance?
I did not.
The IP addresses that Mr. Davis repeatedly asked you about, you remember those questions?
Yes,
Every time you ping off a different Wi-Fi, you're at a different IP address, is that fair?
that's correct.
Whether you're using your phone or your iPad, you're at a different IP address.
That's correct.
So, when he's asking you those questions about couldn't you have determined the location, you would have had to track every message and try to figure out where that was sent from, correct?
That's correct.
Of everything that you reviewed in Facebook, was there any specific discussions about sex between the defendant and Vanessa Robinson?
Not specific discussions, no.
Okay. So, other than solidifying that they knew each other, what did the Facebook records tell you about what transpired in the apartment with the defendant and Vanessa?
Her frequent visits over there and the monies given to her to clean.
But not for sex.
Correct.
Mr. Davis asked you some questions about what kind of individuals you would believe or disbelieve. Do you remember those questions?
Yes, I do.
Have you ever heard the phrase victims are victims for a reason in your cases?
No, I don't
No,
specifically.
you haven't heard that, okay. Do you pick and choose your victims?
I don't.
In your mind, do you ever make the call that any specific victim deserves more or less of your attention as a detective?
I don't.
Vanessa did not get a medical exam, correct? For this case.
That's correct.
So there were no DNA samples from her body to compare to the defendant.
That's correct.
So when you talked about not making a request for any DNA comparison, it's because there's nothing to compare to in this case, correct?
That's correct.
If you would have gotten a search warrant for the defendant's residence, knowing that the allegations were oral sex where defendant ejaculated into napkins, what kind of physical evidence do you think you would have found a month later, 8 months later? What do you think you would have found?
Nothing.
Do you know anything about the admissibility of lie detector results in court?
They're not admissible.
I have nothing further, Your Honor.
Mr. Davis, anything based on those questions?
Yes, Your Honor. So, notice you said the videos from restaurants can be held from 30 to 90 days by the restaurant. Am I correct?
Every restaurant is, every establishment is different, so just based on my experience, every establishment has up to 30 days, up to 60, up to 90. I mean, it all depends on the establishment.
What about employees?
I'm sorry, sir, what's the question?
Did you ever consider to go interview employees of the Fat Burgers restaurant to see if these two individuals had ever walked in there together?
I did not, sir.
Why not?
The duration of the time and photographs of juveniles are not allowed. I'm not allowed to show any individual, specifically adults, photos of other juveniles. So I wouldn't be able to grab Vanessa's photo and just show it to any employee at a restaurant, which could also be a juvenile, because all the information is confidential and due to our policies and procedures with juveniles.
So, in saying that, you can show them my photo, right?
I could.
So why didn't you?
It's not, in this case, it would not be good practice to just show a photo of an individual, and I just chose not to in this case.
But you showed the photos to the people at Caliente, you mailed it to them.
My conversation with Tyler Peterson to administer this photo lineup, he was not given the information for Mr. Raymond Davis. He was neutral in the matter, and that's best practice. He didn't have any knowledge of the specific details of this case, or he did not know where Mr. Davis was positioned in the lineup, whether he was included in the lineup or not. He would have not known that information. So to answer your question, Mr. Peterson remained neutral in the photo lineup.
So, Mr. Peterson was like basically an undercover police officer or something?
He was a staff member at the Caliente Youth Facility.
So, you put this type of investigation lineup in the hands of a staff member?
This has been addressed already.
Yeah.
Move on, please.
So you brought up the fact that a lie detector is admissible in court, correct?
It's not admissible in court, no.
Correct. But can it be used by law enforcement?
It can be used as a tool for an investigation.
So why wasn't this tool used on the defendant or the alleged victim?
Because in this case, if we were allowed to do that, and our procedures for any polygraph is there's a pre-interview and a post-interview, and to have a victim of a sexual abuse incident who's a juvenile re-interviewed, so to say, is not in our best practice, and we don't do that.
But to re-chant it in court is okay.
I apologize, I didn't hear the question, I'm sorry.
But it's okay if she re-chants it on court. That's okay. Recites it on court. What happened?
Her testimony,
Mm-hmm.
that's up to the court, sir.
Why didn't you interview me? Why didn't you interview me or give me a lie detector test?
This has been addressed, please move on.
I might have missed this, so I don't know if it was answered before. So I'm gonna leave it at this question. Why didn't you take me into custody?
Why didn't I take you into custody?
Yes.
The patrol officers took you into custody. They work for the Las Vegas Metropolitan Police Department as officers, and they take subjects with outstanding warrants into custody when stopped or made contact with.
So you were just gonna wait basically until I got picked up?
In most cases, through my experience, that's frequently what happens, sir.
Do you agree that the passage of time hurts an investigation?
Of whose time, sir?
Anyone's time. But the police time. The
Hurts.
passage of time hurt. Shortens memories, lost evidence, people forget. do the passage of time hurt investigations?
I'm gonna go on my opinion of not, because most of the sexual abuse cases that I deal with, there is a passage of time, and it's just memory recollection, and it's not to say that the incident did not happen, so I can't make a decision on that, or I can't answer that question, because in my experience, it shouldn't affect an investigation.
So basically, if somebody got sexually assaulted yesterday, it doesn't matter, they don't report it yesterday, they can report it 3 years later. It's still the same to you.
That's correct, sir.
No further questions, Your Honor.
Anything based on this question?
I have nothing else for the detective.
All right, thank you. Ladies and gentlemen, we're going to take our afternoon recess now. It's 5 to 5. We're going to start back up tomorrow. Oh yeah, I apologize. It is your opportunity to ask any questions if you feel like you have any for this detective. Does anyone have a question for Detective Martinez? All right. Anyone else? Parties opposed, please. May I have the name, please?
Hey, Dean,
Marshall O'Kelly.
on this one, I just need a badge number or a juror number. Okay.
Can I see that? Thank you, Your Honor.
Did you guys already see this one? Sorry. Does either party have any objection to either of these questions?
No.
All right, go ahead, guys.
Thank you, Your Honor.
Okay, first question, Detective. Does Facebook records show geolocations as a neighborhood physical address or IP address?
That's yes. The Facebook records give the IP address, which is pretty much the geolocation of where the phone is pinging from when the messages are sent.
Second question. What was the Facebook warrant's purpose, and what timeline was supported by the Facebook warrant? So first question, what was Facebook warrant's purpose?
So my purpose to get the Facebook warrant was to show the link between Vanessa Robinson and Mr. Davis, because she has stated she had first met him on Facebook and they communicated through Facebook, and they communicated, she stated she would show up because of the communication. So I wanted to show that in fact that was taking place as part of one of my investigative steps.
And then what was, sorry, this is my second question, it was about the timeline. What was timeline was supported by the Facebook warrant?
The records I received were from January 1st of 2015, and I believe they were to that present day that they sent me the warrant, which would have been on or around April of the same year, I'm sorry. I requested January 1st of 2015 to April of 2016, and that was a timeline that I put in the warrant. If that helps.
Ms. Collins, any follow-up? Ms. Collins?
No,
Okay.
no, I was just thinking. sorry.
Okay, no, that's correct. Mr. Davis, any follow-up?
Yes, so, it was a great question by the viewers. So, you could have got the basically the area where it was pinging from, Facebook. You didn't have to get the IP address, you just had to get the area.
I'm sorry?
So, the jurors asked the geographic location. You could have used that basically instead of an IP address. That would have given you a general idea of the location that the communication is happening on Facebook.
So the IP address is somewhat of the geographic location. So your IP address at home is the same for that location of your residence, or should be the same.
And the other question on that one was the Facebook warrant, which we addressed a couple times. So it was basically a warrant to receive evidence from 2015 to, what month was that? April?
April of 2016, I believe.
And any other months you would have no information on investigating on. Am I correct?
Beyond the scope, Your Honor.
Sustained. Anything in regards to those questions, specific questions?
Okay, that's, I'm fine there.
Okay. All right, so during this research, you might not to talk or converse among yourselves or with anyone else on any subject connected to this trial, or read, watch, or listen to any report or commentary on the trial, any person connected to this trial, by any means of information, including without limitation to newspaper, television, internet, and radio, or form or express any opinion on any subject connected with the trial until the case is finally submitted to you. So normally I have calendars on Tuesdays, but another judge was willing to take my civil calendar tomorrow morning so we can keep this moving, so we can get more time in the courtroom. So, if you could be here at 10:15, and we will continue with the next witness. Thank you.
Oh, actually, you're
matters. Detective Martinez, you're free to go. Please don't discuss your testimony with any other witness involved in this case until the case is completed.
I will not.
Thank you. All right, so just go ahead, Ms. Collins.
So based on Mr. Davis's commitment to having the detective on the stand for 2 more hours, I moved everyone, and I will do my best. I mean, if he needs to be held to the same standard the rest of us are. He can't say I'm going to be 2 hours, 3 hours, and take 15 minutes and expect that we're going to keep people here at his beck and call when I've done that all week.
Right.
So, you know, I mean, I'll do my best, but he said he was going to be 2 hours, so I pushed everyone back, and then the investigator's gone for the evening, and
Trying to line up the witnesses.
I'll get someone here. I don't know who it'll be.
Your Honor, I didn't want to torture the jury anymore, so I was told to speed it up, so I speeded it up. I could have kept them there another hour and a half or whatever. But I didn't,
Let's be
in
clear.
respect to the court.
Hold on, let's be clear. I didn't tell you to speed it up.
Mhm.
focus our question on, you need to take the amount of time that you think is appropriate for your case, and I'll allow that. What we cannot do is go into areas that have already been addressed.
Right.
And we can only go into areas on cross-examination that have been addressed in direct. That was my question. I never, in any stretch of the imagination, told you to speak of it.
I agree, Your Honor, but, I mean, I don't want to torture a jury, you know. I mean, I saw them standing up, getting tired, stretching, and, I mean, not all in great shape, so, I mean, my feet are killing me, so.
All right, so the other thing that I wanted to address very quickly, let's see here, just give me a second, because I lost my train of thought. So, as I have discussed, the pursuant to the statute that I had given last week, any motions filed need to be filed 10 days before trial. And I did state that I would consider any motions filed late with an affidavit explaining good cause why they were not filed. I was just going through the motions. I haven't seen any that you filed today. I haven't seen any affidavits attached to those in regards to good cause of why they have been filed late. So I will be issuing just minute orders explaining the reason why those are denied. In regards to the motion to recuse, pursuant to statute NRS 1.235, all motions to disqualify judges need to be done 20 days prior to trial. In an abundance of caution, when you orally requested need to be recused, I did file an affidavit and reach out to one of the criminal judges to see if they could hear that motion. That motion was denied. Today you filed an additional one stating basically the same things, that you feel like you're being treated unfairly, that because of my previous work as a prosecutor on certain types of cases, that you feel like I can't be unfair. I addressed all of those in my affidavit that I had previously filed. Basically everything that you brought up are the same things that you brought up already and that you could have brought up previous to the rules 20 days before trial. So I am denying to have that motion heard or addressed because the previous ruling I find is still appropriate. There has been no new documentation or anything that was placed in the new motion that is any different than the things that were already addressed. So, with that, I know that we told witnesses to be here at 10:15, but if possible, excuse me, the jury, if you guys could be here at 10, so that anything we need to handle is done outside the presence, because I really don't want this jury sitting for 30 minutes, 45 minutes outside, because I know that that's incredibly frustrating.
Yeah.
So, what?
I have a psychological appointment in the morning. I'm getting a second opinion on your doctor's view, already scheduled it.
Okay, so you'll need to make sure that those are done outside of court hours. You'll have to be here by 10 o'clock tomorrow,
I
because
think the appointment was at 8 o'clock in the morning.
okay, so just make sure and let them know that you need to leave to be here by 10.
What if they keep me?
You mean if they commit you?
Mm-hmm. What if they keep me? They can.
I'm sure then you'll let us know.
They don't let you use the phone.
I'm sure someone will let a district court judge know when you're on trial for a sexual assault of a child where you are. But you need to be, unless you are involuntarily committed,
Okay.
you need to be here by 10 a.m.
Mm-hmm. I was used to the afternoon hours and then. And at what point can I bring my witnesses, because they're still staying in hotels?
And that's really up to you. I mean, as soon as the state's done with their witnesses, you can start calling yours. So that's up to you guys.
Yeah, and I cut down my witness list because I don't want to be here for a month, because I don't want 20 witnesses testifying. So I really cut it down to accommodate the state.
Okay, well, it's...
Some people couldn't remain here, Your Honor.
Okay. All right, well, we'll get to your witnesses as soon as the state's done with theirs. So everybody at 10.
Thank you. I'll cancel my appointment, so don't worry, I'll be here.
See you later.